I cannot hear you. No, I can't hear you. You come up here and you click more. Oh, or else there's a window down here.
Okay, I'll look.
All right.
Thank you.
Hey, Carolyn. I don't hear you. Can I hear you? Hello, hello. Hello, hello. Can you hear me now? I still cannot hear you.
Anna, can you hear me now?
Yes.
Uh,
Can you hear me now?
yeah, I have trouble with this every morning.
Hmm. Um. So when you, let me see.
It's when I try and use my headphones.
Okay.
So I just won't use them today, or I'll try later.
Have you been using them?
Yeah, I mean, eventually they start working.
Hmm.
Let me try them again now and see what happens. Can you hear me now?
Yes.
Oh, they're working now. I don't, oh, wait a minute, but
I heard like a little break right there. From me though.
what about now?
It sounds fine.
Okay, all right,
All
thanks.
right. Sure. So can I leave?
Yeah,
Okay. Good luck.
okay, thanks. David, could you fold the clothes? Thanks. Jeff, can you hear me? Okay, thanks.
We just load it down so that way at least you are.
Mr. Wexler, can you hear me? Are you there?
We can hear you.
Good morning, Jeff. How are you?
Good, good. How are you?
Good. Hey, last I checked in, was about 4 o'clock yesterday, and I think who was on, but who'd you get done with, by the end of yesterday?
We're most of the way done with Spanos.
Okay.
So then it'll be Larry Hancock and then Jennifer Borden.
I would guess I'll guess we'll be done with both of those and still have some time to spare today. Things are going faster.
Yeah, that sounds right to me.
So you think it would be, I mean, I guess it'll be up to Ms. Glick, but maybe you'll get through those two and Hernandez today, but probably not Carrasco. You probably would get started.
Yeah, that sounds right. And I cannot remember if Kyle Smith, I feel like he had some questions for Hernandez. Let's see. Yeah, he does. So it's in all likelihood, even if we get through part of Adrian Hernandez, we won't get all the way through because, the Department of Defense has today as a holiday. So
Oh.
Kyle would still be able to ask some questions tomorrow.
Okay. Jeff, I definitely have cross for Carrasco and a little for Novella.
Okay.
I've got I made a doctor's appointment for tomorrow afternoon at 3:30 for something I really need to get looked at.
Sure.
Are you gonna have any objection if I try and reshuffle the order of cross? So,
No, that's just, I would just work it out with the other folks, but that's fine with us.
okay, all right, I'll mention that before we go on the record today and
Okay.
give Ms. Glick a heads up, but I wanted to give you one first.
Yeah, no, I appreciate it.
Okay.
Are you Mr. Zadowski? Thank you.
Madam Hearing Examiner, I would like to just inform you and ask for permission to drop off today at about 4:30-ish.
Is that Mr. Zadowski? Who was
Sorry,
talking?
this is Mr. Lundin with the
Oh,
AG's
okay.
office.
That's perfectly fine. Thanks for telling me.
Thank you.
Ms. Glick,
Yes.
Mr. Marks, before we go on the record, I want to inform you that tomorrow I have a doctor's appointment in the afternoon around 3:30 that is very important for me. And I'm hoping that, I think that we may be having Mr. Carrasco on the stand at that time. And I'm hoping that I will be allowed to change the order of cross if necessary so that I can get my 40 minutes in before that time in the afternoon.
Okay, what time do you have to get off Zoom tomorrow?
I need to, probably about 3:15, I need to be done.
Okay. I don't have a problem with that. Why don't you remind me tomorrow, or when Mr. Carrasco first goes on the stand?
I will do that, Ms. Glick, and I conferred with Mr. Wexler and he had no objection. And it may turn out that I don't need any accommodation. It's kind of hard to predict where things will stand tomorrow afternoon.
Sure.
Thank you.
This is off the record still, David. So I have gotten all of your cell phone numbers. So if we have an outage again, like we did yesterday, and given that today is inauguration day, who knows what might happen. If it does happen again, I will text all of you and let you know what the plan is. David, are you ready?
Yes, ma'am.
Okay, let's go back on the record. We'll continue with cross-examination of Mr. Spanos. And Mr. Simpson, you're up next and you have 10 minutes.
Madam Hearing Examiner, I do not have any questions for Mr. Spanos. Thank you.
Okay, Mr. Bogatko.
Madam Hearing Examiner, staff no longer has any questions for Mr. Spanos, but thank you very much. And thank you, Mr. Spanos, for your time.
Thank you.
Mr. Zadowski, do you have any redirect?
No, Madam Hearing Examiner, we do not.
Okay. Mr. Spanos, I apologize. We should have finished up with you yesterday. I thought there would be more cross-examination. You're excused.
No problem. Thank you very much. Have a
Thank
good
you.
day.
And EPE, you may call your next witness.
We call Larry Hancock.
Mr. Zadowski, are you taking Hancock?
No, this is Jeff Wexler.
I'm sorry, I didn't recognize you.
No problem at all.
Mr. Hancock, are you ready?
Yes, I am.
Okay. Mr. Wexler, are you ready?
Yes, ma'am.
Okay. David, will you please swear Mr. Hancock?
Mr. Hancock, would you raise your right hand, please? You solemnly swear the testimony you're about to give in the matter now pending should be the truth, whole truth, and nothing but the truth.
I do.
Thank you.
Morning, Mr. Hancock.
Morning.
Do you have before you what's been previously marked as EPE exhibit number 42? That is your direct testimony.
Yes, I do.
Was that direct testimony drafted by you or at your under your supervision?
Yes, it was.
Do you have any corrections to your direct testimony?
No, I do not.
Is the direct testimony EPE exhibit number 42 true and correct to the best of your knowledge and belief?
Yes, it is.
If you were posed the same questions that are contained in exhibit number 42 today, would you give the same answers under oath?
I would.
Madam Hearing Examiner, I move the admission of EPE exhibit number 42.
Is there any objection? EPE Exhibit 42 is admitted.
Next, Mr. Hancock, do you have before you your first supplemental testimony? That's EPE exhibit number 43.
Yes, I do.
Was that supplemental testimony drafted by you or under your direct supervision?
It was.
Do you have any corrections to that first supplemental testimony?
No, I do not.
Is it true and correct to the best of your knowledge and belief?
Yes.
And if today you were asked the same questions in that first supplemental testimony, would you give the same answers under oath?
Yes, I would.
I move the admission of EPE exhibit number 43.
Is there any objection? EPE Exhibit 43 is admitted.
And as we turn, Madam Hearing Examiner, to Mr. Hancock's rebuttal testimony, this is EPE exhibit number 44. I just want to alert you and the parties, Mr. Hancock, as he was reviewing just in the last couple of days, did find a correction that we had not previously marked as you had required. Apologize for that and just wanted to get guidance from you. Do you want us to just go ahead and give that this morning?
Yes, and you should re-upload it to Dropbox. Take out the previous version and put in the corrected one so the court reporter will have the corrected one.
Understood. So, Mr. Hancock, if you could turn then to EPE exhibit number 44, that is your rebuttal testimony. Do you have that before you?
Yes, I do.
Was that rebuttal testimony drafted by you or under your direct supervision?
It was.
And I understand that you have a correction to the attachment, is that correct? Or to one of the exhibits?
It's to one of the exhibits. Yes, that's correct.
And can you please identify that for us and then explain what the correction is?
If you turn to exhibit LJH 3-R, page 1 of 1, in column B on the line other transmission, I'm changing the amount to 1185139.
Can you repeat that number, please, so that we get it correctly?
1185139.
Thank you.
In column C on the same line, I'm changing that amount to 1349
690.
And again, can you repeat that one last time?
1349690.
In Mr. Hancock, is that information consistent with the discovery response that you provided in response to one of the city's requests for information?
Yes.
Do you have any other corrections this morning?
Yes, I'm going to continue. In column D, the total there is now 164,551.
I'm sorry, 164.
551.
Thank you.
And then going down 3 lines to the total transmission line, going back to column B, the new number should be 1574977.
Please repeat that again.
1574977.
Okay.
The column C on the same line should be 1765243.
Again, do you mind repeating that?
1765243. And in column D on the same line, the number should be 190266.
And one more time.
190266.
Okay.
And then going down to the final, the total, the double underscore total in column B, that new amount should be 11,900,145.
Can you repeat that, please?
11,900,145.
All right.
And in the column C on that same line should be 13,080,535.
And again, one more time.
13,080,535.
All right. And how about column D?
Column D is 11,80390.
One more time.
11,80390.
And can you explain, Mr. Hancock, for the hearing examiner, what led you to recognize the corrections were necessary?
Well, I was comparing it to one of my other exhibits, and I realized I had left out a line related to the Esleta right-of-way in my calculation. So I had to include that to be all-inclusive on this particular response.
Thank you. And with those corrections is the rebuttal testimony EPE exhibit number 44, along with the exhibits true and correct to the best of your knowledge?
Well, I do have one other correction that was submitted prior.
Yes, please identify that for us. And this is on the original one we.
Yes. And this is on exhibit LJH-6R.
Okay.
And if you turn to page 3 of 4, and down in the column labeled annual accrual difference, was the second to the last column. If you go down to the bottom of the page,
Is that annual accrual difference?
yes.
Thank you.
And down toward the bottom of the page, I want to strike that subtotal of 8,869,904. Just remove it. And in the next column, I want to strike the 1,555,742.
Okay.
And then on page 404,
yes, please.
The final totals, the total on the final line, the last line, and the second to the last column, the new total should be 18,133,861.
Excuse me, Mr. Hancock, which column is that and which row?
The very last row and the second to the last column, which is the annual accrual of difference column.
So you strike out the 27 million number.
Yes,
And what's the new number again?
18,133,861.
Thank you.
And in the next column on the final line, strike out the 5,065,657 and replace it with 3,509,915.
I'm sorry, the first number, 5065.
5,065,657 is replaced with a 3,509,915.
I believe that's all the corrections you have to your rebuttal testimony. Is that correct, Mr. Hancock?
That is correct.
And so with all of those corrections, is the rebuttal testimony EPE exhibit number 44, along with the exhibits, true and correct to the best of your knowledge and belief?
Yes, they are.
If you were posed the same questions today that are presented in EPE exhibit number 44, would you give the same answers?
Yes, I would.
Madam Hearing Examiner, I move the admission of EPE exhibit number 44 with the corrections and the understanding that we will upload the corrected version to the Dropbox.
Is there any objection? EPE exhibit 44 is admitted.
And finally, Mr. Hancock, do you have before you your second supplemental testimony that's EPE exhibit number 45?
Yes, I do.
Was that second supplemental testimony drafted by you or under your direct supervision?
Yes, it was.
And are there any corrections to your second supplemental testimony?
No, there are not.
Is your second supplemental testimony true and correct to the best of your knowledge and belief?
Yes, it is.
If the same questions were posed to you today that are presented in EPE exhibit number 45, your second supplemental testimony, would you provide the same answers under oath?
Yes, I would.
I move the admission of EPE exhibit number 45.
Is there any objection? EPE exhibit 45 is admitted.
We offer Mr. Hancock for cross-examination.
Ms. Stevens, you're up and you have 45 minutes.
Thank you. Good morning, Mr. Hancock. I'm Anastasia Stevens for the City of Las Cruces, and I have some questions for you. Could you turn to your direct testimony at page 5, line 18?
I'm sorry, which lines?
Line 18, starting at
Yeah.
line 18.
Okay.
And I'd like to ask you about these line 18 through the next page. What I'd like to start with is the major plant additions closed to plant and service during the first calendar quarter. Would you turn to exhibit LJH4, please? LJH1, please. And if I don't tell me that misplaced. Can you explain to me why those particular projects, and it's page 4 of 4, correct? On
Yes.
LJH1, the projects that are post test period. Why did you select those particular projects for this out of period adjustment?
Well, we have typically, as we've done in the past, we have a period of time after the base period. We are allowed to include any projects that have been placed in service and are used and useful in serving the customers. And we typically use a 3-month period after the test period or the base period. And these particular projects, we have a threshold of like $1 million to identify major projects. And these 4 projects were the only ones that qualified under our, of those that were greater than $1 million.
And this threshold is a company threshold or a commission rule?
It's a company threshold.
And this idea of doing these updates past the test period, is that a commission statute or rule or a company policy?
I believe it's a commission. I'm not sure if it's a commission's rule, but they've allowed us in the past cases to pick up additional closings to plant that have occurred in a 3 to 5 month period. And we typically use 3 months. And like I said, we pick the projects theoretically we could put everything in there, but we choose the projects that are greater than $1 million based on the threshold that we've established.
And other than that dollar threshold, is there anything unusual or extraordinary about these projects that would make them stand out?
No, there is not.
Did you make is EPE proposing to reduce the test period rate base by 3 months to correspond to the addition of post-test period additions?
I'm sorry, could you repeat that question?
Are you proposing to, now that you're bringing the period for additions forward, are you also making deductions from rate base for the 3 months of continued depreciation on some or all of the rest of your rate base?
No, we are not.
And are you proposing this case to remove the amortization of the plant that was replaced by these several projects?
No, because I don't believe there was plant that was replaced in these instances.
And is that true of each and every one of them? Let's go through them and you tell me, okay? The Palo Verde units 1 and 2 capital improvements, were there any replacements in that $6.3 million?
I don't know.
The Newman unit, is that unit 4? Hot gas path improvements, was anything removed from service to facilitate that project?
There may have been, but I'm not aware of the exact amount.
The Rio Grande to Sunset line, is that a replacement line or a brand new facility?
It's new.
Nothing was there before? New in that sense?
Well, there has been no replacement related to that. This is just a new line they're constructing across for the particular segment.
And the Jornada feeders, are they replacing existing facilities?
Sorry, and the
Jornada feeders.
Can you spell Jornada?
Jornada. Feeders, Feeders.
Again, I don't know if there was any replacement there.
And would EPE agree to move its rate base and depreciation expenses forward 3 months to correspond to its requested addition of plant going forward 3 months beyond the test period?
No, I don't believe we would.
Let's look at a few quick things before we get back to LJH1 on pages 41 to 42 of your direct testimony. I'm sorry, I'm not moving very fast this morning myself. Okay, yeah. You have a table on page 42 that includes the regulatory management suite software at $2,761,190, correct?
That's correct.
And if you go to page 45 to 46 of your testimony, you describe that software and on line 19, it says that the software prepares and extracts data from the company's book and records for regulatory purposes. Have you been involved in some or all of the many bench requests issued in this proceeding, Mr. Hancock?
Yes, I have involved in a few of them, but not related to anything related to the cost of service model or anything of that nature.
So would the delays in providing New Mexico jurisdictional costs relate to this new software?
Well, I don't believe so. I think this new software is, on the contrary, I think this new software allows us to respond to questions from all parties in a more efficient and quicker manner.
And at pages 40, turning to page 49, lines 2 to 3. The question starts on page 48, bottom of page 48, but again, we're talking about this RMS software, correct?
Yes.
And you characterize that software on lines 2 to 3 as allowing the company to meet its technology objectives and strategies to maximize personnel resources and increase financial performance and accuracy. I don't see any mention of facilitating the regulatory review of your books and records. Do you believe that
I'm sorry?
There's no question on the table. Do you believe that the RMF as software has served that purpose in this case?
Oh, yes, I do. I mean, the process prior to implementing the RMS was a very cumbersome manual spreadsheet. And I think now with the development of this software and this module within the power plant system, we're able to, my understanding is that they're able to get this thing done in a lot more efficient manner.
And are you aware of the rate case expenses that the company is seeking in this proceeding?
No, ma'am, I am not.
Okay, let's move on then to Exhibit LJH1. Were you watching a hearing yesterday, Mr. Hancock, when Mr. Doyle denied being a co-sponsor of this exhibit and deferred my questions to you?
I did see that, yes.
Poor guy. Yes, I thought you might have noticed if you were watching. So I'd like you to look at exhibits, your exhibit LJH1 in your direct testimony, and City of Las Cruces exhibits 25 to 28, 48, please.
City of Las Cruces exhibit 25?
25 through 48. And I've tried putting them all up on my screen, and I think it's, for myself, I've decided to throw in the towel and just put the list up and look at them, individually, but I want you to do what you're most comfortable with. Do you agree that CLC exhibits 25 through 48 include all of EPE's filings with the New Mexico Public Regulation Commission under Rule 440, 17.5.440 NMAC from the time of Montana Units 3 and 4 through the present, and therefore are all the ones that relate to the new plant additions that the company is seeking from December 31st, 2015 through March 31st, 2020.
Object to foundation.
Can you expand on that, please, Mr. Wexler?
I certainly can. I think the question asked him to confirm that these are all of a certain subset of the Rule 440s, but Ms. Stevens hasn't yet asked Mr. Hancock whether or not he is familiar with the company's Rule 440 filings, if he has anything to do with those filings, and therefore if he would have any way of being able to answer her question.
Okay, sustained.
Okay, so Mr. Hancock, do you have anything in your role? Do you have anything to do with providing information and assisting the company in preparing Rule 440 filings?
No, ma'am, I do not.
Do you have any reason in your role or in preparation for your testimony in this case to have reviewed the company's 440 filings?
No.
Do you know what's in the company's 440 filings?
I have a general understanding of what's in there, but no, I have never been involved in the preparation of them or in the filing of them at all.
Do you understand what's in them?
Yes, I do.
Okay. And do you understand that what is in those filings is the company's explanation of the reason for a planned transmission, distribution, or generation addition, the estimated costs, and an economic and engineering feasibility analysis?
I have a limited understanding of that, yes.
What portions of that are relevant to what you do? Is it just the cost estimates, or are you involved in the aspects of feasibility or timing or location or anything like that?
Not at all involved in that. I mean, I would be interested in the cost estimates, but I don't see them, and nor am I involved in calculating them.
Now, Mr. Hancock, is it your understanding that with the exception of CCN requests for generating facilities, the company is not required to obtain prior commission approval, and PRC approval, that is, of transmission, distribution, or generation projects, but it is required to make these notice filings under Rule 440?
Like I say, I have a limited understanding of that.
Do you understand that these notices are the only information that the commission, except for in cases of CCNs, these are the only information that the commission has to understand to compare EPE's reasons and costs for a project with the dollar amounts that you are supporting in your testimony for the completed projects?
Well, I understand that concept, but like I said, I have not performed any kind of comparison between these 440 filings and what's actually included in my exhibit.
Could you have performed that analysis, Mr. Hancock?
Well, I could have if I'd have been in that particular role, but that's not the part of my area of responsibility.
And let's think about your responsibility here as a witness, not in your day-to-day responsibilities, but your occasional appearances. I'm sure you love them tremendously as a witness. Would you have any reason to review these in your role as a witness, supporting these figures?
No, I don't. I would not.
And why not?
They were not included in any of my areas that I've sponsored in this filing, nor in my testimony or supplemental or anywhere.
And you understand, though, that Mr. Doyle and actually, I believe Mr. Barachik before him as well deferred to you for detailed support of the project costs.
That's my understanding, but I'm not sure why that's the case. I mean, those are prepared in separate areas, and they don't. And like I've said, and like I stated earlier, I have no involvement in their preparation or in the filing of them. And to be honest, I haven't even seen the majority of them.
Well, and Madam Hearing Examiner, I don't think it's accurate that either Mr. Barachik or Mr. Doyle deferred to Mr. Hancock on the Rule 440s.
Not on the Rule 440s, Mr. Wexler, but on the detailed expenditures. At this level of detail, they deferred the expenditures, not the 440s. Well, actually, I guess.
My recollection is Mr. Doyle deferred to Mr. Hancock on some portion of the exhibit LJH1. I'm certain Mr. Hancock's capable of answering questions about his exhibit.
Well, Madam Hearing Examiner, I guess I will request that the commission take administrative notice under Rule 1.2.2.35 D1C, which relates to taking administrative notice of required filings at the commission. And I don't think that the company disputes that these are its filings, which were made under a mandatory commission rule. And I understand that I know that you've ruled that we don't need to take administrative order or take administrative notice or put commission orders into the record. These are company filings. They are available in the commission's records. They're not entirely easy to find in the commission's records, so I would recommend or ask that they be admitted into evidence, but I don't believe that's absolutely necessary. It's just a convenience to everybody.
In Madam Hearing Examiner, I actually have no objection to them being admitted into the record. We recognize these as filings made by El Paso Electric. And while this witness doesn't have the foundation, Mr. Doyle did sponsor many of these as part of this case. My only objection is to asking this witness about details of these documents for which he's simply not the right person.
Okay. I will admit, I'm not going to take administrative notice because we have these as exhibits. So I'm going to admit CLC exhibits 25 through 48. And I agree with Mr. Wexler that you cannot question Mr. Hancock on these exhibits because he doesn't have sufficient knowledge of them.
Madam Hearing Examiner, may I ask him just some very simple questions on them? I don't think that they go to, okay. That will speed things along here. Madam Hearing Examiner, may I ask him a question, a very specific question about one of these reports that has to do with a post-test year edition?
You can ask your question, Mr. Hancock. Don't answer the question until or if your attorney objects. Go ahead and ask your question.
Yeah, Mr. Hancock, would you look at CLC Exhibit 41, which is EPE's report number 67?
Which exhibit? I'm sorry.
41.
Okay.
Do you know whether this upgrade project is the same as the Rio Grande to Sunset TL 101 that you've got as the $8.475 million of January to March editions?
No, I do not know that.
Okay, well, thank you for telling me that. And let me go backwards and check a few other things. Okay, page 17 of your testimony at line 5 and page 20 at lines 4 through 12.
Yes.
You're referring to amortization of a FERC audit, is that correct? For the cost of a FERC audit?
No, this is not, it's not amortization of a FERC audit. It was.
What is it?
And what was the other page? I'm sorry.
Page 20 lines 4 to 12. Maybe I'm confused and there are two different things that you're talking about in those.
Okay, I'm there. No, this was this is just accumulated depreciation that resulted from a FERC audit years ago, and it was specific to the FERC jurisdiction. And it has no impact on either Texas or the New Mexico jurisdiction. So it's just removed from our accumulated depreciation balance. And this is consistent with the practice we've done for years in both jurisdictions.
So this discussion in these two places doesn't refer to a currently pending FERC audit of El Paso Electric, is that right?
That's correct.
Okay, that's what I need to know. Thank you very much. Appreciate your time. You're done.
Mr. Lundin, you're next and you have 20 minutes. Before you start, I want to welcome Commissioner Byrd. And Commissioner Byrd, Mr. Hancock is EPE's witness who, among other things, discusses plant additions. Okay, Mr. Lundin, you may begin.
Thank you, Your Honor. Hello, Mr. Hancock. I'm Robert Lundin on behalf of the New Mexico Attorney General.
Hello.
Starting at page 2 of your rebuttal testimony, you respond to NMAG witness Andrea Crane. Is that right?
Let me get there. Hold on.
Sure.
Okay.
So I'll repeat my question. It's correct that here is where you respond to NMAG witness Andrea Crane.
I'm sorry, I went too far in my. I think I'm on the wrong. Sorry, I went to the supplemental testimony.
So I'm looking at EPE Exhibit 44, your rebuttal testimony.
Right. Okay. Yes, I'm there. Yes, that's correct.
And is it correct that you claim that Ms. Crane improperly included blended rates in her calculations?
That's correct.
Can you please look at EP Schedule H7, which is part of the company's application filing in this case?
I don't know that I have that here.
I could try to share my screen. It's not going to be too substantive.
Go ahead, Mr. Lundin.
So can you see my screen? Can you see Schedule H7?
Yes, I can.
Is it sufficiently large enough for you to read?
Yes.
Are you the sponsor and preparer of Schedule H7?
I am.
And what is Schedule H7?
It's a schedule of depreciation expense. It has our base period depreciation expense along with the proposed depreciation expense that we are requesting in this case. It's on a total company basis.
And you answered my next question, so I'll move on. Can you please show me where on Schedule H7 the depreciation rates are marked or described as blended?
They are not marked that way on this schedule, but if in column C, which says current depreciation rate, that actually represents the per book depreciation rates that are in the system that calculates, and the per book depreciation rates are a blended rate, but it's nowhere marked on the schedule as such.
Thank you.
Are you saying per book depreciation?
Yes, I am.
Thank you.
Is it true that the proposed depreciation rates found on column F are not blended, but rather they are the proposed New Mexico jurisdictional rates?
Yes, it is. That's true.
Would you agree that depreciation expense is to some extent based on a subjective analysis, in that there are certain unknown factors, such as when an asset will be retired?
Yeah, I would agree.
And would you agree that in this case, there is some uncertainty regarding the ultimate disposition of certain assets?
There is always uncertainty, but when developing depreciation rates, our expert in the field, Gannett Fleming, which is represented by John Spanos, they build all that into the calculation of their rate for each particular item of plant.
If the commission were to reject the company's depreciation proposal in this case, the commission would still have the opportunity to review depreciation rates and expenses again in future rate cases. Is that right?
That's correct. I mean, every time we go in into a rate proceeding, we would present our latest information that we have available from a depreciation standpoint.
Thank you, Mr. Hancock, and thank you, Your Honor. That's all I have.
Before we go on, Mr. Wexler, I want to direct you that for your future witnesses, when they take the stand, they shall have readily available to them the schedules and work papers that they sponsor.
Understood, Madam Hearing Examiner. I think that they are loaded up. Mr. Hancock just wasn't certain where to find them, but we'll instruct future witnesses.
Thank you. Ms. Souls, you're next and you have 10 minutes.
Thank you. Good morning, Mr. Hancock. My name is Mary Lee Souls.
Good morning.
Would you please go to your rebuttal testimony, Exhibit EPE 44. I think that is where you just were, on page 4.
Okay.
You include a table here. Would you please describe the table?
On page 4?
Yes, sir.
Okay. Yes, the table involves a comparison of the rates that were ordered in New Mexico in the last proceeding, in the 2015 rate case, compared to the rates that we are proposing to use in this case from the 2019 Gannett-Fleming depreciation study. And the facilities are the ones that have been shortened our retirement life based on the REA.
Thank you. Am I correct that El Paso Electric is requesting rate-making treatment for Montana Units 3 and 4 for the first time in this case?
That's correct.
Am I correct that Montana Units 3 and 4 were not in service at the time of the 2015 rate case that you referenced?
Yes, that's correct.
Please clarify for me what the current rate value in your chart actually represents on the lines Montana Unit 3, Montana Unit 4, and Montana Unit Joint 3 and 4.
These rates were, there was no, since actually the depreciation study that we used in the last, that was approved in the last filing in New Mexico, was based on a 2014 test year, and none of the Montana units had been included in rates at that time. They weren't even in service. So they were not in the depreciation study from the Gannett-Fleming. What he did, or what Mr. Spanos did, was provide us some estimated rates to use for the Montana units that we ended up using or got approved in this case, in the New Mexico case. So even though 3 and 4 weren't in service, we used this rate for the comparison purposes.
So that rate for 3 and 4 and Joint 3 and 4 has never been reviewed or approved by the commission. Is that correct?
Not for, no, that's correct. That hasn't been reviewed.
And if you're proposing to add Montana 3 and 4 depreciation that's not in current rates, would you change this chart recognizing that?
I don't believe I would. I mean, this is just the current rate column is just an estimate of what the rate was at the time of the last New Mexico case.
But those units didn't exist. Wasn't that your testimony?
That's correct.
Please go to page 16 and beginning at line 17.
Yes.
You're describing your exhibit LJH-1R, which you provided in response to a bench request. Am I correct?
That's correct.
And at line 19, you state column B represents the current depreciation expense on a New Mexico jurisdictional basis, calculated using the depreciation rates approved in the 2015 rate case. Is that your testimony?
Yes.
And would you agree here also that Montana 3 and 4 did not have depreciation rates approved in the 2015 rate case?
Yes, I would agree.
When the commission granted the CCN for Montana 3 and 4, would you agree that El Paso Electric expected the lifetime for those units to be 45 years?
Can you repeat the question, please?
In the CCN proceeding for Montana 3 and 4, would you agree that El Paso Electric expected the lifetime for those units to be 45 years?
Yes, that was my understanding.
And has the commission considered the question of Montana units 3 and 4 at any time since that CCN proceeding?
I don't believe so.
Thank you. I have no further questions.
Mr. Herman, and you have 20 minutes.
Thank you, Madam Examiner. My questions have been asked already by other parties.
Mr. Simpson, you have 15.
Yes, ma'am. I do have a couple of questions. Mr. Hancock, my name is Philip Simpson. I'm a pro se intervener in Las Cruces. Let's stay with EPE Exhibit 44 rebuttal. And let's go to page 5, line 6. So my question regards this this second number in this line, 1,555,742 on a New Mexico basis. I think this number was the amount that was on LJH6R, but you deleted it this morning as a correction. Can you, is this number still valid in this location?
Yes, it is. Just to give you a little background on that exhibit LJH6R, I included a subtotal in there for ease of understanding of which numbers made up those totals. And the subtotal was erroneously included in the bottom subtotal, so I removed it, but these numbers are still appropriate.
Okay.
You can get them from the LJH6R. You just have to add up. You just have to add up all the appropriate lines.
Okay, and that was indicated by the shading on that table.
That's correct. That's correct.
Okay.
I'm sorry.
Let's go to same document, page 17.
Okay.
Sorry, I'm getting there myself. And let's see, line 12. There's a similar number, and my question is, what is the difference between this number and the number that we were just talking about, or why is it different here?
I believe the difference I was provided in a response to RFI or an interrogatory in this case, and I don't recall the number, but there was approximately, I think it's about $40,000 line that was included related to a item of plant that's not in the depreciation study, that has its own separate rate and was not part of depreciation rates that we're proposing in this case. So I'd included it in one schedule and excluded it in the other. It's approximately about $40,000, I believe.
Yeah, I think mathematically the difference is well, I don't want to testify, but can you elaborate on why you have these two different numbers in different places? I mean, I understand what you say about was there an item of plant not included, but I don't understand why it's included in one place and not the other.
I'm going back up to your original.
And I'm sorry, Mr. Hancock, are you saying you're going back to page 5?
Yes, I was going back to page 5 to look at the.
I'm sorry for being a little bit slow, but Mr. Simpson, do you mind reminding us of the question?
Yes, my question is, there's two numbers that are both a little over 1.5 million, but they do differ by an amount we could calculate. And my question is, what is the difference between these two numbers, and why are they different in these two locations? I mean, he described what that difference amounted to, but I'm trying to understand a little more.
My recollection is that it was related to that particular item of plant that I mentioned, but I don't have the specifics with me right now.
So in this first location, you are rebutting Ms. Crane, and you say the actual amount of the increase was 1.555742 million.
Yes.
And in the second location, the increase in depreciation is 1.519639 million. And I guess I still don't understand why those two numbers are different, or what is the difference between the amounts you're describing in one location versus the other?
I could tell you that the specific line that can you go to the exhibit?
The LJHR?
Yeah, LJH 1R.
1R.
Yes.
Is it 1R or 6R?
1R. Well, for now it's 1R.
Okay.
And if you look at line 14,
yes.
Lumen zero liquid discharge, over in the last column, you see that 40,000. In column D, the credit, 40,000 credit,
Yes.
that's included in that, that is included in the 1R, but if you go to 6R, this line is not included in that schedule. Because they were prepared on two different sets of information. I mean, page 6R was developed using the current, all the plants that are impacted by the depreciation study rates. 1R was prepared based on our per book amounts that included this line, but was not in the amounts provided in the depreciation study.
Mr. Simpson, I'm going to pause you for a minute. I want to ask Mr. Hancock a question related to this. Mr. Hancock, if I want to tell the commission what the dollar amount is of the increase in depreciation expense on a New Mexico basis related to the natural gas plants for which EPE seeks approval to shorten the retirement dates, what number do I tell the commission? The number on page 5 or the number on page 17?
The number on page 5.
And why?
Because that's truly calculated from the increase in rates for those specific plants.
Okay, thank you. Go ahead, Mr. Simpson.
So if you remove that line from the calculation from the exhibit 1R, you will come up with an amount that's similar to there's some rounding differences between the two, but you'll come up with an amount that's very similar to the 1.5 million that's shown on page 5.
Okay. So you mentioned line 14, that's 40,150. I would represent to you that's about 10% off of the difference between page 5 and page 17. Would you say that is due to round off, or?
It could be. It's just two different sources of the depreciation. When we filed the depreciation, the amounts that were included in the depreciation study, that was at December 2019 based on that test year. There was some, post that, there was some reshifting of costs between units and might have caused the differences before the rounding or within a few of the accounts. But it's very minimal.
Okay. Okay, well, thank you. I think that is all the questions I have. Thank you for your time.
Thank you.
Mr. Bagatko, you have 15 minutes.
Thank you, Madam Hearing Examiner. Good morning, Mr. Hancock.
Good morning.
How are you today?
I'm doing fine, thank you.
All right, thank you. Am I coming through loud and clear?
Yes.
Thank you. Directing your attention to your direct testimony. I'll give you a moment. If you can open that up and go to page 51.
Yes.
Now they're on.
I'm there.
Oh, thank you, sir. On page 51, lines 9 through 10 of your direct testimony, you identified the license expiration dates for the Palo Verde units as 2045, 2046, and 2047. Do you see that, Mr. Hancock?
Yes.
Those dates can be extended again by the NRC, is that correct?
I'm assuming that's correct, yes, but I'm not aware of any plans to do so.
And do you have any feel for if they are extended, how how many years would be appropriate to extend those? I mean, are we talking in the neighborhood of 10, 20, or 30 years for such an extension, if that happens?
I have no feel for that at all.
Are you aware of any plans by APS or the other interest holders in Palo Verde to extend the life of the Palo Verde units and ask for an NRC license extension?
I'm not aware. I have heard nothing to that nature.
Now, going on in your direct testimony to page 53, and I believe it's lines 2 through 16. I'll give you a moment to get there.
Okay.
I believe there you discussed the 9-year cost escalation rate as being 3.25% compounded annually. Is that correct?
That is correct.
You say 9-year?
I'm sorry, what was that?
Did you say 9-year cost escalation rate?
Yes, 9-year cost escalation rate.
Thank you.
So still going along with our theoretical about the licenses being extended for the Palo Verde units by NRC. If that does happen, do you have any idea how that would impact the decommissioning costs based on 2 drivers, which would be general economic changes and resultant changes in work scope?
Well, I'd have no idea how that would impact that. I mean, we're going to continue to have a decommissioning study every 3 years, and each year the studies changes in scope by some amount, and so I would have no idea how an extension would impact that.
In future decommissioning studies, will consideration of the effects of a possible extension be included in the analysis?
I don't think they would be included in the analysis until the extension took place.
Fair enough. Thank you, Mr. Hancock. Still on page 53, directing your attention to lines 2 through 4, you state that the 2016 TLG study estimates decommissioning costs to be roughly $2.74 billion. Do you see that?
Yes.
Now, does this number include the cost for spent fuel disposal?
No, it does not.
And why is that?
Well, the spent fuel disposal is the responsibility of the DOE.
Could you explain further? Are you talking about the cost is set by DOE, or DOE is actually physically responsible for the disposal of spent fuel?
The DOE is responsible for the disposal of the spent fuel. We have facilities in place to store the spent fuel, and those costs are included in the study. But the ultimate disposal of the spent fuel is the responsibility of the DOE.
But the cost of disposing the spent fuel, is that not something that would be prospectively passed on to the utility and thereby the utility's ratepayers?
I'm not aware of that at this time.
Did you have a chance to read the pre-filed testimony of staff witness Raj Solomon and also the pre-filed testimony of EPE witness Knight on the issue of spent fuel disposal?
No, I did not.
Are you aware of a court order from the DC Circuit Court that's basically, as I understand it, suspended the associated fee for spent fuel disposal until such time as a legally adequate fee assessment can be conducted?
I am aware that the fee was suspended, yes.
Do you have any idea, or let me put it this way, do you anticipate that this fee will be reinstated in the near future, maybe within the next 6 months?
I have heard nothing of that indicating that at all.
Have you been following any of the work that I take it is being performed to determine what the legally adequate fee assessment will result in terms of a fee associated with spent fuel disposal?
No, I have not.
And then based on past experience or your personal knowledge, do you have any idea what that fee will ultimately be determined in terms of spent fuel disposal?
No, I do not.
So earlier you indicated that the physical responsibility for the spent fuel lies with DOE, correct?
That's correct. That's my understanding.
Thank you. Do you have any idea of where and how DOE would dispose of that spent fuel?
Well, initially it was intended to go to Yucca Mountain, but that's been nixed, and I don't think there's any plans at this point for any future disposal of the. I'm not aware of where they're planning the DOE is planning to dispose of it at this time.
And when you talk about Yucca Mountain, is that where a high level, I mean, not that they're going there right now, but Yucca Mountain is a facility that's equipped to handle greater than Class C GTCC waste. Is that correct?
I really couldn't say that. I would assume that's correct, but I don't know.
And in the event things get back on track with the disposal of fuel rods and other high-level radioactive materials, are you tracking or attempting to assess the cost of transporting and ultimately disposing of that material and how that will be passed on to ratepayers? I'm sorry for the long question, but please answer if you're capable, Mr. Hancock.
No, I'm not tracking that.
And if and when they go ahead and follow through on their assessment of the associated disposal fee, does EPE have any plans to update the commission on the impact of that fee in terms of how it will affect EPE's ratepayers?
I'm not aware of the plans.
All right, Mr. Hancock, if you'll bear with me just for a moment, I'm going to just make sure that's it, because like Mr. Herman, a few of my questions were already taken care of by other counsel. So just a moment, please. That's all I have for you, Mr. Hancock. Thank you very much for your time this morning, Madam Hearing Examiner. I pass the witness.
Commissioner Byrd, do you have any questions for Mr. Hancock?
I do not. Thank you.
Okay. Mr. Wexler, I allocated 10 minutes for redirect. Do you have redirect?
I have a few questions. Thank you. Mr. Hancock, this morning when you were talking with Ms. Stevens, she asked you about whether the company would agree to recognize depreciation expense through March 31st, 2020 to offset post-test year additions. Do you recall that question? Why did the company not reflect depreciation expense for those that post-test year period?
We do not ever project depreciation out past the test period or past the base period.
Objection.
For any of the plan.
Go ahead, Ms. Stevens.
I don't believe that that's what the question I asked him was about. I asked him whether they would project depreciation amortization of plant rate base amortization, not depreciation expense.
Do you accept that, Mr. Wexler?
Subject to looking at the transcript, certainly. I mean, may I continue?
Yes.
And do you understand that to be the question, Mr. Hancock?
Well, I'm assuming she's referring to accumulated depreciation on the plants that were added post base period, but we never calculate or apply accumulated depreciation to any of the plant past the base period date or the test period date.
And is it correct that the depreciation expense recorded in the first quarter of 2020 was offset by other plant additions that were included in the company's post-year adjustments?
Could you repeat that question?
I can. I'm asking if the depreciation expense recorded in the first quarter of 2020, so that period of time we're talking about, was offset by other plant additions that were included in the company's post-test year.
Absolutely.
Turning to a different subject, Mr. Hancock, you were asked by Ms. Sewells about Montana units 3 and 4. Do you recall that set of questions?
Yes, I do.
Are you aware that there was a depreciation study in the last, or the depreciation rates were an issue in the previous rate case?
No, I'm not aware. They were not an issue. As far as my recollection is that the 2014 study was accepted as is.
And do you know if that 2014 study included forecasted rates for the Montana units?
Yes, it did.
Do you know if those forecasted rates are reflected in Mr. Spanos's depreciation study?
In the 2014 study?
That's correct. If he includes information about those.
Yes, he included some forecasted rates for Montana, but they weren't, obviously there was no there was no plant or accumulated or cost removal information related to those plants since they weren't in service yet. But yes, he did include forecasted rates for the Montana units. And that's what was reflected on the table that Ms. Sewells was referring to.
That was going to be my next question. I believe that's page 4 of your rebuttal testimony. Is that correct? We just confirm that for me.
That's correct.
And do you know that 2014 depreciation study, was that approved by the PRC in the final order in that case?
Yes.
Thank you, Madam Hearing Examiner. No further questions.
Can you hold on just a minute? I lost sound. Just a second. Can you say something, Mr. Wexler?
Yes, Madam Hearing Examiner. Can you hear me?
Okay, I still don't have sound. Just a minute. Okay, I think I can hear now.
Okay.
Yes.
We had completed the redirect of Mr. Hancock. Do you need me to repeat anything or?
So no, I can look in the transcript.
Understood.
So if staff or any interveners have redirect, will you raise your hand, please? Recross. Okay, then thank you, Mr. Hancock, you're excused.
Thank you.
Let's go ahead and take our break and resume at 10:30. And EPE, you may call your next witness at that time.
Thank you.
Look, we get snacks and everything, yeah. In case you have long hours. Jim had all day, so he definitely needs snacks. So excuse me, hungry right now. So is it all? Because sometimes they lose their voice.
David, can you hear me?
Yes, Your Honor.
I can't hear you. Can you say something again, David?
Yes, Your Honor.
Okay, now I'm good. Thank you.
I'm ready when you are.
I think we're still waiting for the next EPE witness.
I think she's on, but maybe we can't hear her quite yet.
Hello?
Now we can hear her.
Okay.
Are you ready, David?
Yes, Your Honor.
Okay, let's go on the record. Mr. Wexler, you may call your next witness.
EPE calls Jennifer Borden.
Ma'am, would you raise your right hand, please? You solemnly swear the testimony you're about to give the matter not pending should be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Good morning, Ms. Borden.
Good morning.
Do you have before you what's been previously marked as EPE exhibit number 50? That's your direct testimony.
Yes, I do.
Was that direct testimony drafted by you or under your direct supervision?
Yes, it was.
Do you have any corrections?
No, I don't.
Is it true and is that direct testimony true and correct to the best of your knowledge and belief?
Yes, it is.
If you were asked the same questions today that are posed in that direct testimony, would you give the same answers under oath?
Yes, I would.
I move the admission of EPE exhibit number 50.
Is there any objection? EPE Exhibit 50 is admitted.
Ms. Borden, turning to your supplemental testimony that's been previously marked as EPE exhibit number 51, do you have that before you?
Yes, I do.
Was that first supplemental testimony drafted by you or under your direct supervision?
Yes, it was.
Do you have any corrections?
No, I do not.
Is it true and correct to the best of your knowledge and belief?
Yes.
If you were asked the same questions that are posed in EPE exhibit number 50 today, would you give the same answers under oath?
Yes, I would.
I move the admission of EPE exhibit number 51.
Is there any objection? EPE Exhibit 51 is admitted.
Ms. Borden, do you have your second supplemental testimony before you? That's EPE exhibit number 52.
Yes, I do.
Was EPE exhibit number 52 drafted by you or under your direct supervision?
Yes, it was.
Do you have any corrections?
No, I don't.
Is it true and correct to the best of your knowledge and belief?
Yes, it is.
If you were asked the same questions that are posed in EPE exhibit number 52 today, would you give the same answers under oath?
Yes, I would.
I move the admission of EPE exhibit number 52.
Is there any objection? EPE Exhibit 52 is admitted.
Ms. Borden, do you have EPE exhibit number 53 before you? That's your rebuttal testimony.
Yes, I do.
Was that rebuttal testimony drafted by you or under your direct supervision?
Yes, it was.
Do you have any corrections?
No, I don't.
Is your rebuttal testimony true and correct to the best of your knowledge and belief?
Yes, it is.
If you were asked the same questions today that are posed in your rebuttal testimony, would you give the same answers under oath?
Yes, I would.
I move the admission of EPE exhibit number 53.
Is there any objection? EPE Exhibit 53 is admitted.
And finally, Ms. Borden, do you have before you EPE exhibit number 54? That is your third supplemental testimony.
I'm sorry, Mr. Wexler, can you start again? Finally, Ms. Borden?
Do you have before you EPE exhibit number 54? That's your third supplemental testimony.
Yes, I do.
Was EPE exhibit number 54 drafted by you or under your direct supervision?
Yes.
Do you have any corrections?
No, I don't.
Is EPE exhibit number 54 true and correct to the best of your knowledge and belief?
Yes, it is.
If you were asked the same questions that are posed in EPE exhibit number 54 today, would you give the same answers under oath?
Yes, I would.
I move the admission of EPE exhibit number 54.
For any objection? EPE Exhibit 54 is admitted.
Thank you, Madam Hearing Examiner. With that, we tender Ms. Borden for cross-examination.
All right, Ms. Stevens, you're up and you have 2 hours, and I will probably take a lunch break before you finish up.
Thank you, Madam Hearing Examiner. Good morning, Ms. Borden. I'm Anastasia Stevens. I represent the city of Las Cruces. I think you probably know that Ms. Budke referred to you some detailed questions about EPE's accounting for regulatory expenses and outside expenses, correct?
I believe it was Ms. Prieto, but yes, I do remember that.
It was Ms. Prieto, okay. But before we wade into that morass, I'd like to cover some easier, like non-numerical points to get rolling, okay? Let's start with the fuel and purchase power cost adjustment clause. You, Mr. Schiestel, and Mr. Rasick all address the company's request for a fuel and purchase power cost adjustment clause.
I'm sorry, Ms. Stevens. Can you start that question again? And I wasn't getting the names you were mentioning.
Oh, you, Mr. Schiestel, these are tremendous spelling problems, aren't they? And Mr. Barasic all addressed the company's request for a fuel and purchase power cost adjustment clause reconciliation. Would you agree to that?
Yes.
And you yourself addressed the fuel clause reconciliation in 3 separate testimonies. Your direct exhibit 50, pages 41 to 43. Your rebuttal, exhibit 53 at pages 14 to 15. And your third supplemental testimony, exhibit 54 at page 2. And would you agree that that last one, the third supplemental, specifically responds to a bench request from the hearing examiner asking for EPE's position on the significance of commission approval of EPE's request to reconcile fuel and purchase power costs for 2017 through 2019?
Yes, that's correct.
I still do not fully understand EPE's position despite all this testimony. Do you agree that the term reconciliation is not used in the New Mexico Public Utility Act?
Objection foundation.
Overruled, she can say if she doesn't know.
I don't know.
Ms. Borden, are you the sponsor of EPE? Are you the preparer of EPE's, one of the preparers of EPE's annual fuel and purchase power cost adjustment clause reports to the commission?
Yes, I'm responsible for the filing of the annual 550 report with the commission.
I'm sorry, the annual 550 report?
Yes, sir.
Thank you.
And are you involved in filing the monthly fuel clause reports, Ms. Borden?
Yes, I am.
What exactly are your responsibilities as manager of regulatory accounting and compliance?
In general, or specific to this to the 550 filings?
Start with in general, so we get an idea of what's the line between accounting and regulatory compliance, and then we move to the 550.
So I'm responsible to oversee the regulatory reporting and accounting to the respective commissions. We file annual reports, monthly reports relative to, and specifically related to our fuel information for each respective jurisdiction.
And in New Mexico, one of the things you also file is a periodic fuel clause continuation filing. Is that correct?
That's correct.
Now, are you significantly involved in that process when it occurs?
Yes, I am.
Now, do you consider the present case to be a continuation file? Well, do you understand, do you know that whether the continuation filing requirements are part of PRC Rule 550?
Yes, they're part of Rule 550. There's a clause in there specifically addressing the continuation of the
So you are,
yes.
And so you are familiar with Rule 550?
Yes.
And are you familiar with the parts of the Public Utility Act that relate to these fuel clauses?
If you're referring to Rule 550, yes. If you're referring to something else, I'm not sure what you're referring to.
Okay, so you don't know the statute, but you do know the rule. Is that a fair?
I'm familiar with the statute. I wouldn't be able to tell you exactly what is in it at this point.
So my question was whether the term reconciliation or something like that appears to your knowledge in either the rule or the statute, Rule 550 or the statute.
Without looking at it, I would have to review it again. I don't know it verbatim. I would have to look at it and make sure it's not in either one.
And what is the basis of the company asking for a quote reconciliation unquote in this case? Is it that rule or is it something else?
So we have in the past requested and have gotten approval from the commission when we have requested a reconciliation of specific years in the proceedings, specifically in the last case, we requested reconciliation for 2015 and 16, and the commission approved that request.
And when you refer to the last case, which last case was that?
Let me go to, so it's the 2015, sorry, the last fuel continuation filing, case number 180006 UT.
And now that you're in a general rate case, what is the basis again for your request for a reconciliation of 3 years of fuel costs when we're in a general rate case with a 1-year base period?
So I do know that the FPPCAC is at issue in this case, and I believe that is the reason, excuse me, why we're requesting the reconciliation of the past 3 years in this case.
And when you say the fuel clause, the FPPCAC is at issue in this case, are you saying that this is a continuation proceeding?
No, sorry. No, that's not what I'm saying.
Okay. So what does EPE believe that if the commission grants the requested reconciliation for the years 2017 through 2019, it will be making a conclusive finding that every cost incurred by EPE that was recovered through the fuel clause between those years was prudently incurred?
Can you repeat the question?
Does EPE believe that if the commission grants the company's request for reconciliation, it will be making a conclusive finding that every single cost incurred by EPE that flowed through the fuel clause for those 3 years was prudent?
I can't answer what the commission's order, what the commission in their order mean exactly. Like I don't, I can't say what the commission's meeting is in their order, if that makes sense.
That makes sense, but I think I asked you whether EPE believes that would that be EPE's interpretation? What does EPE believe, not what the commission says?
Okay, so our interpretation is that the commission agrees that our accounting for and recovery of the fuel and purchase power costs are properly recovered from our New Mexico customers. That's our understanding.
Now, do you mean accounting in the sense that you match the dollars, or are, again, my question to you is, do you believe that does the company believe that a reconciliation finding would be the equivalent of finding that those costs for those 3 years were prudent?
Well, as you mentioned earlier, Steve Barachek does discuss the prudency of our fuel and purchase power costs in his direct testimony. I discuss and cover the accounting for those costs.
So would an acceptance of the so-called reconciliation request by the company, in your mind, in the company's mind, equate to a finding that the costs for 3 years were all prudent?
If the commission said it was, then yes, I would.
And if the commission just says that EPE's request to reconcile those costs is approved, in EPE's mind, would that be a final finding of prudence?
I would not assume that. If the commission does not say that, I would not assume that.
And does the company agree that the commission can at any time go back and review the prudence of costs that go through the fuel clause?
Yes, of course. As I stated in my testimony, that the FEPCC is subject to a commission prudence review.
So you do not take this case to be a prudence review?
No, it's my understanding that a prudence review is a completely separate proceeding.
And I hate to do this again, but do you think by approving the reconciliation, does the company believe, and am I correct in asking you to speak on behalf of the company, because Mr. Schiestel and Mr. Raschik, who I guess probably rank higher than you, also address these issues? But I think you're the one who actually does the reporting, so that's why I'm asking you.
Can you repeat the question?
The commission, is it the company's position that by approving the requested reconciliation, the commission would be finding that each and every cost that went through the fuel clause for those 3 years was reasonable?
I think I already answered that, but again, if the commission does not explicitly say that in their order, my answer is no, I would not assume that that is the case.
And what about if the commission denies EPE's request for reconciliation? In EPE's view, would that mean that the commission has determined that the costs, or some of the costs or revenues that went through the fuel clause that you report on, were not reasonable?
That would be my same answer. If the commission stated in their order that some of our costs were not prudent, unless they said that in their commission, in the order, I would not assume so.
I'm going to pause you for a minute, Ms. Stevens. I have a question related to this. Ms. Borden, I'm looking at, could you turn to your third supplemental testimony at page 3? This is related to what Ms. Stevens was asking you.
Yes.
At lines 1 through 3, you talk about the significance of commission approval of EPE's request to reconcile. And you say the significance is that the commission agrees EPE properly accounted for and recovered fuel and purchase power costs from New Mexico retail customers. So I have 2 questions relating to that statement. What do you mean EPE properly accounted for those costs?
So what I mean with that is we, on a monthly basis, we file our 550 reports, which detail the fuel and purchase power costs by FERC account. And then those costs are compared to our monthly revenue that we recover and show a calculation of that month's over under calculation, and also show the calculation for the fuel and purchase power cost adjustment clause factor, which is applied to customer bills in the second preceding month. So that's what I mean is we report on a monthly basis how the costs are accounted for as far as where the costs are recorded on our general ledger, and then the comparison of those costs, those actual costs, with the revenue we recover from New Mexico customers, and we show the comparison.
Okay. And so I think you just answered my second question. What do you mean when you say the commission agrees that EPE properly recovered the costs? Did you just answer that too?
Yes, I did. So it shows the factor calculations, and it shows the comparison of the revenue recovered from customers, comparing that to the actual fuel expenses.
Okay. Thank you. And Mr. Bagatko, I just wanted to ask you if you could get back to me on this. I don't recall that any staff witness addressed this and testified as to whether the commission should approve this request. If you could just get back to me by tomorrow morning when we start the hearing, and let me know if I'm correct. If I'm not correct, if you could point me to which testimony discusses that.
Yes, Madam Hearing Examiner, thank you.
Thank you. Thank you. Ms. Stevens, you may proceed.
So one last question on the fuel clause, Ms. Borden. Were you watching the hearing last week when Mr. Schiestel testified in response to Ms. Souls that the purpose of the fuel clause reconciliation is, in his word, precisely to find that the purchases are, those purchases for the 3 years are reasonable and prudent? Did you hear that testimony?
No, I did not.
Well, then I can't ask you whether you agree, but I will leave it at that. Let's go to another non-numerical question because I want to warm up as well as you. Okay, if we could look at your
more about
another non-numerical question because I want to warm up as well as you. So let's turn to number 50, Exhibit 53, your rebuttal at pages 5 to 6, please.
Okay.
And this goes to this here. You're talking about disagreeing with one of Mr. Garrett's adjustments because he recommends a 5-year amortization, and the company believes that 3 years is appropriate because of the duration between rate cases. Is that a general proposition here? Is it the company's position generally that amortizations between rate cases should be based on an assumption of 3 years between rate cases?
Generally, yes.
And seeing as there is some disagreement between the company and Mr. Garrett about that interval, would the company agree to record a regulatory liability and credit carrying charges at its weighted average cost of capital if more than 3 years elapse between rate cases in the instances in which you're using a 3-year amortization? For example, this REC costs and demand response pilot program costs, and later on your request for rate case expenses. I'm sorry, that was an awfully long question because I referred to the examples after I asked the question. So let me go back to the question. And would the company agree? Because would the company agree to a reversing essentially regulatory liability after the 3-year point on these costs that you are contending will be fully recovered over 3 years because it's a 3-year interval?
Is there a specific liability you're talking about? I wouldn't be able to answer that unless I knew what the specifics are.
Well, I believe that the 3-year ones here you've, in this particular piece of testimony, you're talking about two REC amounts, renewable energy certificate cost amounts.
Right.
This is pages 5 to 6, bottom of page 5 to top of page 6 of your rebuttal. So we have the carryover of the REC costs from the 2015 base rate case, the costs procured for RECs in 2015, the demand response pilot program, and I would add to these the proposed 3-year amortization of rate case expenses. So for those 4, would the company agree to recording a regulatory liability and credit back to ratepayers in the next rate case with carrying charges amounts recovered over the approved amounts?
I'm sorry, I didn't mean to interrupt.
No, please answer. I should have.
I don't see how we would have a liability related to REC costs or demand response programs. So I can't answer that question.
Do you understand that now that presently the company does have a RPS cost rider, which has a true up aspect to it?
Yes, I do have a general understanding of that.
And so I think what I'm suggesting to you is, by agreeing, if the company were to agree that this amortization would reverse, which I would reverse, or whether you call it a regulatory asset or not, in this instance, you're calling it a regulatory asset, that at the point it hits full recovery, it would start to become a regulatory liability, which would subsequently at some point be returned to ratepayers. Is that something that would be acceptable to the company?
If there was a separate rider, as you mentioned, an RPS, the RPS rider, where we are ordered to keep track of the revenues versus the expenses, and in which there is a true up mechanism related to that rider, yes, we would agree.
I'm asking now about within this rate case through the general rate case concepts of regulatory assets and regulatory liabilities, would you agree?
Because there is no a separate rider for rate case expenses, and because the commission has not required us to keep track of the over recovery of rate case expenses, no, I would not.
Okay. So could you turn to work paper A3 adjustment? I'm trying to stay away from numbers still, but we're getting a little closer. Would you turn to work paper A3 adjustment number 33, please?
Yes.
And gee, I thought I had it saved somewhere better on my, it's going to take me a second because I thought I had it somewhere obvious and I don't.
Okay, it's going to take me a moment as well.
Good.
I'll get there.
Ms. Stevens, did I miss it? Did you give us a PDF page?
A3 adjustment 33, and I'm sorry for this one, I did not note the PDF page. And to be honest, I've been going to the original filing and just using those handy dandy things in the margin.
Okay,
Handy dandy things. That's very, very articulate, but you know what I mean.
I do. It looks like on my version, it's PDF page 138 is adjustment number 33. Is that what you were referring to?
PDF page. Well, I'm starting with, hold on a second. I've been working with the full application, and you must have gone to something else that's way beyond 138.
I'm just looking at the work papers. Let me just ask, are you talking about adjustment number 33, page 1 of 7?
I'm talking about adjustment number 3, the 33. Yes, page 1 of 37. And I'm talking to you and not finding it myself. So give me a second myself here. This is being nasty to me. Okay. So Ms. Borden, are you there?
Yes, I am.
Okay. And you discussed this adjustment at pages 37 to 38 of your direct testimony. We're looking at the adjustment is entitled Regulatory Assets and Liabilities and Other Additions / Deductions to Rate Base. I'd like to focus on the lower part of that page, the other deductions portion, other additions and deductions portion. The Palo Verde water agreement was entered into in 2010, was it not?
I believe that's correct. Yes.
And would you refer to CLC exhibit number 15, please? My goodness, have you got everything on paper? Wow.
I thought I did. Maybe not. Let's see.
Find you on the screen?
CLC 15. Okay.
And do you agree that that's a copy of the PVNGS effluent purchase and sale agreement that you're referring to? that was produced in response to an Attorney General interrogatory?
Yes, it is.
Madam Hearing Examiner, the city moves to admit CLC Exhibit 15, the Palo Verde Agreement.
No objection.
Okay, CLC Exhibit 15 is admitted.
And would you agree that that contract, I won't, too many agrees here. Would you agree that that contract required the participants in the Palo Verde Nuclear Generating Station to make 4 lump sum payments of $7.5 million each in 2010, 2011, 2012, and 2013, Ms. Borden?
Let's see. The dollar amounts do sound correct. I'm just not sure about the years. Do you have a page number where that is?
I will find it in a second, I think. Oops, maybe I won't find it in a second.
I found it. It's page 5 of 34.
Thank you. So the payments were broken, the $30 million of payments were broken into 4 annual payments, is that correct?
That's correct.
And would EPE's share have been based on its 15.8% interest in Palo Verde?
Yes.
So its annual payment would have been, if I've done the arithmetic correctly, $1,185,000. People with calculators.
Yes, $1,185,000.
Which EPE paid annually quite a few years ago, is that right?
That's correct.
And EPE did not seek to recover those flat fees in its 2015 New Mexico rate case, or any part of them, did it?
No, it did not.
So why does EPE believe that the NMPRC should now, more than 10 years later, authorize rate recovery of amounts paid so long ago?
Well, I'm not sure why EPE did not request this in the 2015 case, but in my review of the assets on the books at the end of the base year, I did identify this item as something that should be requested in rate base. It is a prepayment that is specifically related to one of our generation units that are in service and servicing New Mexico customers. Although the amounts for the unamortized amounts for these prepayments were not included back in the 2015 rate case, the amortization for these this prepayment was included in the cost of service as part of O&M for PV.
Are you saying this is being collected in O&M? I don't believe I followed your testimony. What portion of this was being collected in the 2015 rate case?
As these costs are amortized, they are amortized to, as I mentioned in one of the RFIs, the amortization for this water is amortized to account 519, I believe, FERC account 519, coolants and water.
and that is an amortized amount in addition to the annual payments, that's in addition to the annual payments that you do make under the contract? Is that what you're saying?
Yes, it's part of the contract to receive the water at Palo Verde.
So if I understand your testimony correctly, you are presently, without this commission having ever approved a regulatory asset, you have been treating these 2010 through 2013 payments as a what? A regulatory asset? Or what is the basis for this amortization if they were not being, if there was no specific order approving amortization of this specific amount, Ms. Borden?
We're not.
Ms. Stevens, excuse me, I think we need to ask her first. Do you agree that the commission never approved a regulatory asset for this?
Do you, Ms. Borden, I believe your testimony indicates that the commission has never approved a regulatory asset for these amounts. Is that correct?
This is not considered a regulatory asset. It's another addition. It's other additions to rate base, similar to prepayments. Prepayments are included in rate base as another addition to rate base. And this is very similar. It is a prepayment in regards to the nature of it. The reason why it was not included in account 165, which is prepayments, is because it was related to this agreement. But as it should be treated the same way as a prepayment. Prepayments, as they are amortized to O&M, they are included in our cost of service, and there is no prior regulatory approval for those other than them being included in rate base.
And would you look at CLC Exhibit 17, please?
Okay.
And I'm not quite following your explanation now, because when the city asked about why you had not previously obtained approval of a regulatory asset, your answer here seemed to state that the request to recover the agreement costs do not satisfy the definition of regulatory asset, which is the FERC definition. Rather, these costs satisfy the definition for 186 miscellaneous deferred debits. And is that your position, or are you now talking about account 519? Again, can you clarify for me?
My position is that these unamortized costs on our balance sheet satisfy the FERC Uniform System of Accounts for account 186.
And is inclusion in rates of things that are out of period cost that the company may have recorded to 186, is the commission, this commission, not FERC, this commission free to reject what the company has put into that account?
Objective form, I just didn't follow the question at all.
Is it your understanding that once a cost is recorded in account 186, account 186, that the local commission, whether it's the PRC or the PUCT, does not have to allow the company to recover that, but may apply its usual rate making standards to those costs?
I can't answer that question.
Well, I put it a different way, Ms. Borden. If is there a corresponding miscellaneous deferred credits account for costs that you have, for savings that you have discovered from 7 to 10 years ago in your records?
We do have, as other credits to rate base, we do include customer deposits, we include customer advances, which both reduce rate base. Those are not considered regulatory liabilities, but other deductions to rate base.
The city moves to admit exhibits CLC Exhibit 17, EPE's response to CLC interrogatory 5-18.
No objection.
CLC Exhibit 17 is admitted.
And you do agree that these do not meet these costs do not meet the regulatory asset definition, right, Ms. Borden?
I agree, and we're not requesting them as a regulatory asset to be included in rate base.
Now let's quickly look at the Newman ground lease, which is also on your adjustment 33.
I'm sorry, I'm sorry, the Newman
ground lease, ground land lease, ground. Would you look at CLC Exhibit 14, please?
Okay.
And would you agree that that is a copy of the Newman ground lease agreement that the company provided in response to a company AG discovery request?
Yes, it is.
The city moves to admit Exhibit 14, the Newman ground lease.
No objection.
CLC Exhibit 14 is admitted.
And would you look at CLC Exhibit 16? And would you agree that CLC Exhibit 16 is your response, which it very much tracks the explanation in CLC Exhibit 17 concerning the Newman land lease not satisfying the definition of regulatory asset, but satisfying the 186 miscellaneous deferred debits category?
Yes, that's correct.
The city moves to admit Exhibit 16.
CLC Exhibit 16 is admitted.
And in that agreement, Ms. Borden, do you agree that the company made 2 lump sum payments in December 2008 and December 2009, each in the amount of $1.1 million?
Yes, that's correct.
And the company did not seek to recover those costs in its 2009 rate case, did it?
No, it did not.
And it didn't seek to recover those costs in its 2015 rate case either?
No, it did not.
And again, why now? Why are you asking for this now?
Again, as I answered in relation to the PV effluent water agreement, I reviewed the company's balance sheet and identified these prepayment amounts as as amounts that should be included in rate base, because there are, in essence, prepayment amounts related to these agreements.
And in both of these agreements, the company has ongoing obligations on an annual or monthly basis to pay for the rent in the case of the Newman lease and effluent deliveries in the case of the Palo Verde agreement. Is that right?
That's my understanding, yes.
And those are in rates as well? Those have been in rates all along, those amounts?
Yes, they have been.
Let's go to move on to work paper A3 adjustment number 10. And in this case, I'd like to use the version not in the big original application, but in EPE exhibit 1, the response to paragraph G of the second procedural order. And this time, if you're with me, I did take down, Mr. Wexler, the PDF page number is page 207 is the start of that exhibit.
Thank you.
207 out of 313.
Okay, I'm there.
And now we're into FERC account number 928, Regulatory Commission expense, are we not? We're starting to get warm. Let's go to page 3 of that exhibit, please. And am I correct in assuming that anything that has in the allocator direct other is not being sought for recovery from New Mexico customers?
That's correct.
So we can focus on the ones that say direct New Mexico, correct? Right?
Yes.
Can I ask you why the line 6, New Mexico Energy Efficiency New Programs, although it appears to be a reversal to 0, it is allocated to direct other?
The costs related to the energy efficiency programs are recovered through a separate rider, the EU ECRF.
So other includes different recovery mechanisms as well as different physical service jurisdictions. Is that a fair statement?
Yes.
Is that EU ECRS?
EU, energy use, oh my God, EU CRF. I may miss a letter in that.
Thank you.
I won't go there because if I try, I think she's a little bit off, but we know what we're talking about. Okay, let's start with the New Mexico costs. We have a number, item 3, regulatory act, excuse me a second. Line number 3, regulatory activity in New Mexico, $71,148. You appear to be requesting the actual test year amount for recovery in this case, is that right?
Yes.
And what does regulatory activity in New Mexico cover in light of the fact that there's some specifics below?
Yes, it consists of, as it says below, general regulatory expenses related to various cases and or filings. Maybe these were probably filings to satisfy requirements for specific reports that are filed with New Mexico. These would not be specifically related to a case number.
So they might be related to a case number, or they are expenses that are clearly not related to a case number?
I believe they're not related to a case number. If we had costs related to a case number, we would have separately identified them.
Got you. Thank you. So now we have the line number 9, the New Mexico Renewable Procurement Plan filing, case docket number 18-00109-UT, and the test year amount is $101,949. Are you aware of the status of case number 18-00109-UT during the test period 2019?
No, not specifically.
Do you know whether case number 18-00109-UT was completed, was reached a final order before the end of the beginning of the test year?
I don't know. I wasn't involved in that case specifically, so I don't know the specific dates.
And I believe Mr. Schiestel deferred this to you, but if you don't know, I will put it in the brief regarding the docket, because it is what it is.
Okay, yes. Can I say something on that?
Yes.
If, and I'm not sure if this is the case, but if the case did end before the test year period, we do often receive invoices from attorneys months later. So that could be the case.
Okay.
But
Well,
I don't know when the case ended.
okay, and I'll ask you about that when we get into that awful document that that was referred to you. You're not gonna like it. I'm not gonna like it. So let's go on, and I believe the New Mexico rate case expense amortization was explained to us in a discovery response, and that does relate to the recovery of the previous rate case expenses, right? From the 2015 rate case, line 11, that went away because it actually went away during the.
That's correct.
By the end of the test period.
Yes.
Now the line 14, the 2019 New Mexico rate case expense. This says that the amount is $6,439, and it appears that you've negated that out. Is that correct?
That's correct.
Filing? Can you tell, you must have been involved in the preparation of the 2019 New Mexico rate case, were you not, Ms. Borden?
Yes.
And that case was fairly far along before the company asked to postpone it till 2020 based on the recent deal with acquisition with contract to be acquired by IIF. Is that right?
Can you repeat the question?
Yeah, so what for the point that rate case, the 2019 New Mexico rate case, had proceeded to a certain point before the company asked to be relieved of its obligation to file that case in July 2019, was it not?
Yes, that's correct.
And surely the company spent more than $6,000 preparing that rate case? Is that fair to assume?
Yes, that's correct.
So why does this show the test year amount as $6,439?
So in the base year, at the end of 2019, this $6,000 is an amount that should not have been expensed. It should have been deferred. And so we're taking it out through the adjustment to not reflect it in account 928.
And what about the other expenses that the company undoubtedly incurred to develop that 2019 rate case before it was aborted? Where are those costs?
Those costs were deferred, and they've been deferred as a regulatory asset since we're requesting them to be recovered over 3 years.
Now, I thought that what you're requesting, what you're seeking to recover over 3 years is your projection presented by Mr. Schiestel and reflected on page 2 of 3 of 2020 rate case expenses. Am I right about that?
That is correct. That estimate includes, that was the estimate to completely that estimate was for the case entirely. Yes, that 2.4 million.
And that's the 2.4 million is for the present case that we're in right now, correct?
That's correct.
So I'm asking why the test year, which I assume are off your books, amount for the 2019 rate case, the one that did not come to fruition, why there isn't a higher number in this column or whether why there isn't a higher number in this column. Just tell me that and then we'll figure out where the number is.
It's not in this schedule because those amounts were deferred. And this is an expense account. Account 928 is an expense account. So it would not be reflected here.
And are they, when you say they're deferred, are they somewhere else in this rate filing?
Yes, they are in account 182.
And are they being proposed to be collected in this rate case?
Yes, they are. They're a portion of that is included in the estimate for this case.
Now, I think we're going around in circles here because I think you just said that the estimate for this case, the 2.4 million, is all the prospective costs beginning with this 2020 case. And I believe that's how Mr. Schiestel described it, as being based on quotes from consultants and such, and it's all prospective.
Objective form, vague.
Yeah. Do you understand? Is it correct for us to understand that the looking at pages 2 and 3, that the line 15 2020 New Mexico rate case expense amount had no cost in the test period, and you are proposing to amortize brand new costs incurred in 2020 and now 2021 over 3 years at the rate of $800,500 per year?
I don't believe that's what I'm saying.
Well, then explain to me what you're saying, because I'm trying to separate the 2019 rate case expense from the 2020 rate case expense.
So the 2019 rate case expenses shown here, the 6,000, should not have been expensed. It should have been deferred. We have amounts in our deferral account, which is included in this case, that are part of that original $2.4 million estimate that Jim provided, the witness she still provided.
And going back up to page 2 of 3 here. This is Mr. Schustel's estimate, is it not?
Yes, it is.
Are you saying that one or more of these line items includes amounts that were incurred in 2019 and were deferred and put into these numbers? Because that's how I'm interpreting what you just said, and I may be completely wrong.
Some of the costs in the estimate were incurred in 2019.
In 2019 and in connection with the previous rate case?
In connection with this case, we did have costs incurred for the previous case that when the commission agreed to change our base year from I believe it was 2018 to 2019. At that point, the costs that we had incurred at that point, we case management together with legal looked through what we had incurred at that point and determined what work had been done that would not have to be recreated. Or, for example, there were a couple of studies where, because the base year changed, the study would have to be recreated. So at that point, that identification of those costs, those were expensed and no longer deferred. The other costs were legal and case management identified where those costs were still relevant to the case, whether it was a 2018 base year or a 2019 base year. They're still relevant, so they remained deferred and on our books.
Hold on a second here. Could you refer to CLC Exhibit 20, Ms. Borden? This is an exhibit that Mr. Schustel provided and testified to on last Monday. Seems like a lifetime ago. And maybe, does this look familiar to you? Have you seen this before?
CLC Exhibit 20.
CLC Exhibit 20, it's Exhibit JS22S from Mr. Schustel's original second supplemental testimony. And he talked about it during his cross-examination last week.
I'm seeing his testimony, yes, and okay.
So there's a column, the first column with dollar figures says actual costs at December 11th, 2020. In light of what you've just said, are some of these actual costs, costs that were incurred in 2019 in connection with the rate case that did not go to completion?
I did not prepare this, so I would not be able to answer that definitely, but my assumption is yes. I have not, I'm not familiar with this exhibit and I didn't prepare it, so I can't answer you yes or no.
Okay, well, set this one aside because when we get into the Exhibit 11, Exhibit 9, the trial balances, it may come up again. And that's the one that was deferred to, the one that's really ugly. In the meantime, now let's quickly go back to, if I can find it here.
Ms. Stevens, I'm going to pause you for a minute. I just want to get clarification on one thing you were talking about. Ms. Borden, you said some costs that were incurred in 2019 in connection with preparing a rate case were deferred. So are those costs, were they placed in a different account?
Yes, they're in account 182.
And so are those deferred costs, are they in addition to the total rate case costs that for which EPE seeks recovery in this case?
No, ma'am, they are not. They're part of the 2.4 million.
Okay, thank you. Go ahead, Ms. Stevens.
Okay, so let's go back just before we go into those nasty trial balances. Let's take another look at page 3 of 3 of adjustment number 10 of work paper A3. And again, I'm in EP Exhibit 1, page 209 of 313.
Okay.
Okay, let's look at the last item, the number line 19, the New Mexico Long-Term Purchase Power Agreements, case 19-00348 UT. The $41,719 test year amount, is that actual test year costs incurred on your books, Ms. Borden?
Yes, those are the costs that were paid in 2019.
And the $143,577 adjustment, is that actual or projected cost after the test year?
They are actual costs, they're not projected, but those are costs that we were invoiced for after the end of the base year.
You paid them after the end of the base year, correct?
Yes.
And the company request here is the sum of those amounts, is that not so?
Yes.
So, and that is being requested as, that's direct to New Mexico. So New Mexico picks up all of that, correct?
That's correct. It's a New Mexico case.
And if your proposal were approved, the company would have the opportunity to recover through rates $185,000 for that case each and every year in which the new rates are in effect. Is that what the effect of treating this as an expense item achieves?
So when I look at account 928, I do look at it in detail, especially relating to Texas versus New Mexico cases, and specific cases throughout the year. Although we won't have, for example, we may not have a long-term purchase power agreement case every year. The cases that we see on a year-to-year basis do change. So we won't have the same cases every year, but the level of regulatory commission expense that we're requesting is consistent with what we've seen in past years. And again, it's not the same cases every year.
Would you agree that the last time the company sought approval of a long-term purchase of power agreement was with Macho Springs back in 2012 or so?
I can't recall.
Would you agree that the company does not do annual cases for purchase power agreements?
Yes, I just said that we don't necessarily have a long-term purchase power agreement case every year. But we do have other cases that do come up and they're not annual. So like I said, the level of cost in total for account 928 for regulatory expenses reflects the variation of cases that we have in front of the commission on an annual basis.
And why would you combine 2 years worth of costs on that particular case under your own theory to be reflective of some sort of ongoing annual amount?
These, like I said, we were invoiced for this case. We received the invoices later, early during the year, and that is why I included them as part of the cost of that case.
Do you know when this
really reflect again that level on a total account basis of what our regulatory commission expenses are for New Mexico cases?
Do you know when that case was filed, Ms. Borden?
It must have been filed in 2019. I don't know exactly when it was filed.
Do you know when it went to hearing?
No, not off the top of my head. I do not.
I guess we will refer to the order then. Now let's go up to the New Mexico Newman 6 CCN. That's case 19-00349 UT. And again, you appear to have taken, is it correct to say that you took actual test year expenses that would show up on your books in 2019 as column C? In column C, is that what that 63,000 is?
Yes, it is.
And then the 72,270, what does that represent?
Those are also costs that we were billed for in the early part of the year for that case.
How do you define the early part of the year?
Between January and March.
And why is March your cutoff, please?
It was at the time we were preparing this adjustment. That's what was available. That's the information that was available to me.
And you didn't quite answer my first question on the long-term purchase power agreement case, but the $135,777 in the company request, just like the $185,296,000 for the long-term purchase power agreements. If the company's requests were granted, the company would recover that amount in rates every single year until these rates are changed. Is that right? Just a yes or no?
That's correct. But like I said, it's not specific to that case. It's a total account level of cost for regulatory cases in any specific year or in any year.
And do you know when was the last time EPE sought a CCN for gas-fired generation in New Mexico, Ms. Borden?
I don't know.
Were you here just a little while ago when they were talking about Montana 3 and 4?
Yes.
Do you understand those to be the last gas-fired generation CCNs in New Mexico?
I believe they were, yes.
And they went into service, I believe you heard, in 2016?
Ms. Stevens, you can't testify.
Do you know when
She said she didn't know.
All right. Let's now turn to, this is ugly. Does anyone, Madam Hair Examiner, maybe this would be a good time for a lunch break. I want to go into that trial balances exhibit that I was using, and it was Ms. Prieto said, send it to Ms. Borden. It's a lot of little fine numbers, and it's kind of, once we get rolling in that, I think we probably want to bounce around. So if you're thinking of a lunch break, I might ask it to happen now.
Sure. Let's come back at 12:30. And Ms. Stevens, remind me what that exhibit is so I can have it up when we start.
Yeah, it's CLC Exhibit 9, and it's 400 pages of monthly trial balances presented. Unfortunately, in a PDF format, it's easier to move around in the spreadsheet, but I didn't post the spreadsheet. If you want, and the company will agree, I could pull up the spreadsheet and circulate it, but I was following, the rules about PDFs.
Right, I have the PDF.
You do have the PDF. You
Yes.
have the PDF, right? Yeah. If you want the, okay, we'll use the PDF then, but it is arduous to bounce around 400 pages. So thank you.
Okay, so let's go off the record and we'll come back at 12:30.
Stevens, this is David Lee, the court reporter. How are you?
Good.
I take it we're going to go through a bunch of numbers now?
Yeah, we'll try to go slowly, and I hope that we don't need to hit too many of them. This is a really nasty spreadsheet.
That's fine. I would just ask that you try to say them crisply because sometimes it's hard to tell what's going on with the Zoom connection.
Yeah, and I guess I could ask the hearing examiner as well, would it be beneficial to not, when I'm reading off a number from this thing, drop the pennies or round them off, or shall I just read the number and have the witness read the number, the full number?
I think you should read the full number, but you do tend to speak numbers quickly. You really, I agree with the court reporter, you need to enunciate.
Enunciate, thank you.
Whenever you're ready, Madam.
We're still waiting for the witness.
Must we?
Would make your job easier, wouldn't it?
Here we go.
Okay, let's go ahead and go back on the record. Ms. Stevens, you may continue.
Hello, Ms. Borden. So we're getting to the hard part here, I'm afraid. Are you familiar with Section 6213(3) of the Public Utility Act concerning costs?
I am a little familiar, yes.
And when you prepare, when you do the accounting, when EPE does its own accounting under the FERC system, are you making any adjustments or subcategories in order to reflect the differences in the FERC definitions of regulatory expenses, regulatory assets, regulatory case expenses, other outside expenses, to coincide in your mind with what section 6213(3) requires of the company?
Do you have a specific section or what specific?
Well, if we could turn to schedule H1, page 10 of 10 and page 11 of page 10 and 11 of 12. And I had previously brought that up if I got it in the right place.
Madam Hearing Examiner.
It is that page.
Hold on, Ms. Stevens. Yes.
Is that 16.13.3?
16-13-3 is how it's done in New Mexico.
Thank you.
And now we're looking at company schedule H1, pages 10 and 11 of 12. And in my complete application version, those are pages 1988 and 1987 and 1988, if I can dig that up.
Okay, I'm on page 10.
Okay, but actually probably page 11 would be preferable. And do you see there that under account number 928, the account number 928 is broken into regulatory commission expense litigation, regulatory commission expense NOSA, and regulatory commission expense PV, which I assume is Palo Verde, correct?
Yes, that's correct.
And then when you go up to account 923, which is outside services employed, that one is on H1. It's broken into outside services employed and outside services employed litigation. Is that right?
That's correct.
In your exhibit, in your adjustments, your A3 work papers, and if you'd like to confirm also in Schedule A3 itself, those breakdowns into litigation and non-litigation categories do not appear, do they?
I believe they do not.
And where then do they appear in your accounting?
So they appear here in Schedule H1 because the instructions for Schedule H1 under Rule 530 requires that those costs be identified on separate lines for those accounts. So this is where those costs are shown broken out, because we're following Rule 530 as far as the rate filing package.
And anywhere else, is that breakout reflected anywhere else in the company's application, and subsequent testimonies and exhibits?
Not that I'm aware of. Again, I believe this is the only place where we're required to show that breakout.
So now let us turn to the dreaded trial balances, CLC Exhibit 9.
Madam Hearing Examiner, I do want to be clear. I believe that Ms. Prieto does have some testimony supporting those costs.
Okay.
So let's try to pick up where Ms. Prieto left off in the trial balances exhibit, that CLC Exhibit 9. Oh, and Madam Hearing Examiner, I don't think this is necessary for me to do, but if it is, I'd like to ask to take administrative notice of the FERC account descriptions, accounts numbers 923, 928, and 182, which is what Ms. Borden referred to as where the rate case expenses from the 2019 case were parked.
Yeah, that's not necessary. My understanding is the uniform system of accounts is part of the the federal code, so it can be cited.
Thank you. So Ms. Prieto, Ms. Borden, are you with me in Exhibit 9 now? And I'll ask you to turn to page, where it is, 367 of 449 of the PDF. Which at the moment I don't have.
Did you say page 367?
367 of the PDF version. It's numbered 366 on the teeny tiny header.
Thank you.
And so 367. And do you see towards towards the top there are about a dozen entries under regulatory commission expense 920 FERC account 928.
Yes.
Would you agree that those amounts, those entries, those itemizations don't match? Well, first of all, would you agree that those itemizations do not break it down into litigation costs versus anything else, as we were just talking about with H1?
Yes, I agree. This is our trial balance, which is summarized by FERC account and sub account. We don't break out litigation on our trial balance, which is an internal document.
And how do you define the sub accounts or the explain to me? Well, I guess they're not necessarily sub accounts here. If we go over to the account/project column, how does the company make distinctions between, there are a couple of sub accounts, I guess, in there, but how does the company make its determinations as to what to identify as a separate project to track?
When there's several ways that's identified. In this case, in account 928, as you could see, there's several projects, and those are identified as needed to separately identify costs.
Those separations are not, somewhat overlap, but are not identical to the ones on your exhibit, your work paper A3, page 3 of 3, are they?
Work paper A3.
The one we were looking at that has the individual cases.
It does.
Adjustment 10 of A3.
So my adjustment 10 was broken out further. It was not necessarily by project. The amounts on adjustment 10 were identified, were split out by docket number, and that was column B, if a docket number was available.
And for example, on the trial balances, what would the second item, Gen-Bus-Seg XP blanket, want to speak that out in full words and tell me what it contains?
The general business segment expense blanket are miscellaneous costs related to generation. That's what the GEN stands for. Or general, I'm sorry, general business expense. I don't know off the top of my head exactly. I wouldn't be able to list those out at this moment.
And in this set, you do have an entry for the 2019 New Mexico rate case, and it is the $6,438.80, which I guess is the same as the $6,439 on work paper adjustment 10. Is that right?
Yes, that's correct.
And now if we could go up a couple of pages to where's my note? Page, I thought I had a note here and I don't. To page 361 of 449. This is the outside, towards the bottom of the page, it starts with account 923, outside services employed.
Give me a second to get there.
The lower part of page 361 on the PDF, not on the header, which is almost invisible.
Okay, I'm there.
And that carries over onto the next page as well. Would you agree that there again, legal costs or litigation costs are not separately identified?
That's correct. It's the same reason. This is an internal document for the company, and we don't separate litigation costs on the trial balance.
So at what point do you separate litigation cost as defined by the New Mexico statute 62-13-3 for regulatory purposes?
In preparation of Schedule H1, our legal department identified they reviewed the invoices in the base period, and they identified what was related to litigation costs and provided that to us so that we could provide that breakout on Schedule H1.
And were you listening when I cross-examined Ms. Prieto and we talked about the fact that the company objected to providing those invoices or invoices to support account 923 because according to the objection, it was irrelevant?
I think I did hear that.
Do you know that the company did not provide that level of detail to the city when we asked for it?
I do know that, I'm not sure exactly what you're talking about, but I do remember providing or helping and providing an answer to a request for information from the AG. They asked us to provide details in account 923, and we provided information or the breakout of account 923, both by vendor, description of the service, and the amount for the total amount of that 16.8 million outside services during the base period.
And again, that was not broken down by litigation versus non-litigation, because that was something that was a determination you made later in preparation for this case. Is that is that the right chronology?
So we prepared Schedule H1 during the preparation of the filing of the case, so that would have happened first. The response to that RFI was we responded to the request in the RFI as far as providing the detail by vendor. I don't believe that the request was to provide a breakout between litigation and non-litigation costs.
Let's go to pages 360. No, we're at 63. I should see 163. Where is my? I'm sorry for being sloppy here. 180. You also were discussing 183, and if we can find a 182 and 183, right? You said that those rate case expenses that were incurred for the 2019 rate case, but are being carried over to the 2020 rate case. Here it is. We're in account number 182. Is that what
you have
just
a page number?
I will in a second. I want to make sure that I've got the right account number. 182, is that right? Is that correct?
Yes, it's 182.
And is, I hope I'm in the right month still. I think so. Yeah. If you would turn to page 350 out of 449 on this PDF.
Okay.
At the lower portion of that page starts the tell me which one. There's a 182.2 and 182.3 on this page. Are we just talking about 182.3 when you're talking about where the rate case expenses were treated as a deferred account?
Yes, that's correct.
So we are in this lower block, the 182.3s, is that right? And that carries over to the next page, I believe.
Yes.
And again, and this is entitled Other Regulatory Assets. Is it the company's position that the rate case expenses from the 2019 rate case that the company asked to not complete, to postpone, satisfy the definition of a regulatory asset?
Yes,
Why?
because these are costs that we are deferring in connection with this case to, and we're requesting them, as Jim Schiestel has testified in his direct testimony.
Ms. Stevens, I'm going to interrupt to ask a question. Ms. Borden, did you receive commission approval to create a regulatory asset for those costs?
We have not, not specifically for this case, but we have in the past, this is prior precedent, where we have deferred the costs so that we can request the approval of them in the case. We have gotten approval in all the cases that I'm aware of.
Okay, thank you.
Ms. Borden, could you elaborate what approval did you get in prior cases regarding rate case expenses carried over from a previous rate case? I'm not following you.
I did not say a prior case in that I'm saying costs incurred for the current case are deferred, as in the cases here, we've deferred these costs. They are labeled as 2019 on the account project because that is where on our internal books, our internal account code, that when we began the 2019 case, we set up a project and we named it 2019. Those costs, as they came in, were charged to this project. In middle of 2019, when it was decided to postpone the case, those costs remain just for historical value as far as where they were originally booked in that project. Those costs, like I said before, we went through when the decision was made to postpone. We went through, legal went through, case management went through, and analyzed what costs were still relevant to the case, whether or not it was going to be filed in 2018 or 19. The issues of the case did not change substantially, to my understanding. It was primarily what changed was the timing of the filing of the case, which changed the base period. So those costs that are deferred on our general ledger are costs for this case. They're relevant to this 2020 case.
They are costs, though, that were incurred, in fact, in early 2019 to prepare the prior case that didn't happen. Is that right?
I'm going to object. I think that mischaracterizes her testimony. She indicated that those costs are relevant to this case, the preparation for this case as part of the rate case expenses that EPE is requesting.
Sustained.
Let's go to the next page, page 351 of 449. And here they're actually, it's about the fourth item. I think it's the fourth item on from the top of the page. And it says other regulatory assets, 2019 New Mexico rate case. And the prior month balance was $434,786.97. There was no current activity in, I guess, the month of December. So is it correct to say that the cumulative amount spent on that 2019 rate case in 2019 was $434,786.97, Ms. Borden?
Like I said, yes, the $786.97 are costs related to this case. Some of them were incurred at the beginning of the year, when we were preparing the 2019 case. And those 434,000 are relevant and related to this case filed with a 2019 test year.
What would be a good month to look at for, because we're now, because this was a spreadsheet turned into a PDF, what would be a good month, in your opinion, to look at to see get a snapshot of what EPE's costs and accounting looked like as about the time that case was put on hold or postponed? Would it be June, May, July? I don't know how long your costs lag your actual activity. What month would you recommend?
Objection vague. I'm not clear on good for what purpose.
What I'm asking Ms. Borden is to point out, since these trial balances are done on a monthly basis, which month of 2019 would be helpful in indicating to us what the level of activity was in the 2019 rate case on a real-time basis. Ms. Borden, do you understand what I'm asking you for? I think it would probably be June or July, but I don't know whether your invoices, how long your billed invoices lag.
I think you would have to look at every month. If you wanted to capture the activity in that account project combination, you would have to look at every month if that's what you want to do to capture the activity.
What I'm trying to capture actually is the point at which it went from being an expense item in 928 to being a deferred item in 182. Does that make my request any clearer? Because you testified, I believe that's how it was handled. It was an ongoing expense while it was occurring for the previous rate case, and then it was set aside, I guess, and then reevaluated for carryover into this case?
I object. Again, I don't think that's correctly characterizes what this witness has testified to you.
Well, why don't you?
Go ahead.
May she testify, Madam Hearing Examiner?
So let me see if I understand your question. Let me say it and you tell me if it's correct, Ms. Stevens. You are asking her if she can direct you to the month or months within this exhibit that would reflect activity related to preparation of a rate case in 2019.
Yes, Madam Hearing Examiner, with a slight twist. I believe that all of the early months of the year will show activity. What I'm trying to save some time is to find perhaps the point at which that activity, ongoing activity as an expense, was halted and got moved into this into the 182 regulatory asset deferred expense category. And I understand that might not be only in one single month. Is that a fair question, Ms.? Well, is that permissible, Madam Hearing Examiner?
Yes. Do you understand the question, Ms. Borden?
Yes, I do.
So can you answer that?
Yes. As costs are incurred for this case, they are deferred. They are not expensed and then deferred. So you will not see what I believe that you're asking for is cost in an expense account then moved to a deferred account, unless there was a misclassification where an invoice was booked to the 928 account that should have been deferred. But as I said, as costs are incurred and invoices are paid, that is directly recorded in this account 182.
So while I look for a random month, can you explain how that 6,439 amount appeared in the end of the year? Then, if everything was being deferred?
Yes, as I said, let me try to say it a different way. At the end of the test year, we looked at account 928 and we saw that $6,000 that was recorded to account 928 and identified that as an invoice that should have originally been charged to the 182. So that's what happened in that case, in that instance.
So on a month-by-month basis then, Ms. Borden, are you saying that there was a line item for the in a 928, there was a line item for the 2019 rate case expense, but you never put anything in there, or you immediately reversed it? Can you kind of clarify? I'm looking for some actual month examples, but if you could clarify what you're saying about what the intent was or the practice was, I'd appreciate that.
I don't understand your question.
No, you said that it was always being deferred as the invoices came in. They were always being deferred. I'm trying to figure out in real time when you were expecting the rate case to go forward. First of all, you start, obviously, I would assume during 2019, as you were, until you hit that point where you decided to withdraw that, you were expecting that rate case to go forward. And then when the change came, when you withdrew it, something must have been done, or maybe something wasn't done. But you do have a line item on these trial balances in the expense category, as well as in the 182 regulatory assets category for the 2019 rate case. So I guess I'm asking you, if it was always being treated as a regulatory asset, why do you have an expense column also? An expense row, not column.
I believe that when the work order was set up, that account was included as an account to that was valid to be used when recording journal entries to that work order. When work orders are set up, they're set up so that all the accounts that will be used going forward are available. So the reason why we would see an amount in the expense account 928 for the 2019 case would be because an invoice was mistakenly coded to the expense account 928, instead of the deferred account 182. So throughout monthly closings, those accounts are reviewed, and if there is a misclass, those would have been reclassed within the year. Like I said, that $6,000 that you see in adjustment number 10 for account 928, we identified that amount at that time, that should have been reclassed as well.
Okay, I think I maybe have a visual or an actual example that perhaps would help clarify this more. If you could turn to page 185 of 449 on Exhibit 9. And do you see under 928 regulatory commission expense, in the middle of that block, the 2019 New Mexico rate case, it has a prior month balance of $72,404.22. And then the June current activity is a reversal of $14.54. Is that right?
Yes.
And then it leaves a cumulative, boy, my eyes aren't good enough, cumulative $389.68. Is that what you're talking about, that things hit the books and then get reversed or get moved?
That's correct.
And if we were to go back for this month here, which is June, should we be able to find the 721454 being added to the New Mexico rate case, 2019 rate case, account number 182? If we go, I'm just doing this on the fly, so pardon me for being inarticulate. And that is 172. I think I found it. But, well, that is the right batch of things. I'm looking for the actual transaction. And I do not see that there, Ms. Borden. I see towards the bottom there, 2019 New Mexico rate case, and it has a prior month balance of $246,441.47 and no activity in the same month. Let me make absolutely sure we're in the same month. Yeah, we're in the month of June. So where did that $72,000 that was taken out of expenses go to?
The beginning balance for that line is $420,176.96.
And you're in the expense account, right?
No, I'm on page 172 on the line for the project WR719.
Bouncing around.
I think you're reading the next line.
Am I reading the next? Oh, okay. So you're saying there was a removal of $55,968.99, but that is still not the same as the $72,014.54 that was the indicated reversal on the account 928. So where would the difference be then?
So this is summarized again by account project. So that's the column in the middle is a summary of all the activity for the month. So there could have been other reclasses. This may have been the 77,000 could have been added here, but then offset by other credits to that work order in this month.
Which we're just not going to see, is that?
That's correct. We don't have the journal entry detail on the trial balance.
Okay, I think I've probably asked as much as I need to do about that, except I will ask these other regulatory assets, do these pick up anything that is recorded as a 923 outside expense, other outside expense, or is this all regulatory when it's called regulatory assets?
I don't understand the question.
Among the activities that show up in this 182.3 other regulatory assets, would we be seeing similar reclassifications or reversals of actual expenses during the test period, the calendar year 2019? Would some of those costs also be moving over from being treated as expense items to being treated as regulatory assets in 182.3?
I don't know.
Thank you. That's all my questions. I appreciate your help in slogging through this. I really do.
Thank you.
Ms. Borden, I just have two questions. I want to follow up real quickly on some things Ms. Stevens asked you. And she might have asked you this, but I just want to make sure. Does anywhere in EPE's application list by expense the regulatory commission expenses hyphen litigation? Does that appear anywhere in EPE's application?
It is on Schedule H1. The litigation expenses are identified separately in a separate line item for account 928.
And my question is there any other further breakdown of that in EPE's application?
No, there is not.
And
Not
same,
that I'm aware of. I'm sorry, not that I'm aware of.
okay. And same question relating to the category regulatory commission expenses, not litigation. Is there any further breakdown of that anywhere in EPE's application?
Well, so on adjustment 10 does show the detail, but it's not broken out between litigation and non-litigation. So all of the regulatory commission expenses are included in there in adjustment 10 in additional detail. But again, it's the litigation versus non-litigation is not separately identified there.
Thank you.
Madam Hearing Examiner, may I ask one question on that?
Oh,
answer?
your time's up.
I'll come back to it later, I think.
Okay, Mr. Lundin, you have 40 minutes.
Your Honor, I actually have no questions for this witness. Thank you very much.
Mr. Herman, you have 20 minutes.
Thank you. My questions have been asked by Ms. Stevens.
Mr. Simpson, you have 10 minutes.
Thank you, Madam Hearing Examiner. I have no further questions.
Mr. Bagaco, you have 10 minutes.
Madam Hearing Examiner, our 10 minutes, we will waive those as no longer necessary. Thank you.
Okay. And Ms. Borden, I have one question for you that I gave you advance notice of. Am I correct that EPE seeks to recover $324,416 for D&O liability insurance on a New Mexico jurisdictional basis?
No, that amount, the $324,416 is on a total company basis. The New Mexico jurisdictional amount is $66,299.
There was a beep while you were giving that number. Could you repeat it again, please?
Yes, it's $66,299.
Okay, thank you. Okay. Mr. Wexler, I allocated 15 minutes for redirect. Do you have any?
Briefly, Your Honor. Ms. Borden, you were asked about the litigation and non-litigation expenses at length. Does EPE follow the rules of the commission in filing its schedules?
Yes, we specifically follow Rule 530, which provides information on the schedules that we file. That, in particular, Schedule H1, there is information related to H1 where it requires that we break out litigation costs in accounts listed on Schedule H1, and we have done that. We have broken out our litigation costs within the base period for account 923 and account 928. It's also my understanding that the litigation costs that are we aren't there, those are the only litigation costs in the filing, and they've been identified as per the rule.
And is that the way that EPE did that for this particular filing? Is that consistent with other EPE cases?
I don't remember. I would assume yes, that we would have filed it the same, but we did follow the rules for this case.
And finally, do you know if Ms. Prieto includes testimony supporting some of these costs?
Yes, she supports our A&G costs.
Thank you. No further questions.
Okay.
A minute, Judge.
So,
did you say A&G costs?
Yes.
Thank you.
So if raise your hand, staff and interveners, if you have any recross. Okay, Ms. Stevens.
Thank you. Ms. Borden, I have one question that applies to reclassifications. The 928 expenses, do those include internal regulatory litigation expenses as well as external expenses?
What reclasses are you referring to? The
928, for 928, the regulatory commission expenses, do that include internal as well as external expenses?
Internal costs, such as filing costs. Yes, it would if it was related to litigation and it was recorded in account 928. Yes.
And how about employees whose major functions involve preparing regulatory filings?
I don't believe internal costs are allowed to be recorded in account 928 per FERC rules.
And and what about 923? That is by definition outside expenses. Is that correct?
That's correct.
That's it. Thank you.
Commissioner Byrd, do you have any questions for Ms. Borden before I excuse her?
No, ma'am, I sure don't.
Okay. Thank you very much, Ms. Borden. You're excused.
Thank you.
And Mr. Wexler, you may call your first witness. I understand it'll take a minute or two to
It will.
get settled.
It's Mr. Hernandez. While we're switching, one clarification, Madam Hearing Examiner. We're prepared to replace the Hancock testimony as we discussed earlier with the corrected exhibit. And I just wanted to make sure I understood what you would like us to do. My understanding is we would remove the previous version and replace it with the new version that includes the corrections, all corrections that Mr. Hancock identified. Is that correct?
Yes.
Thank you.
Is the next witness Mr. Slocum or Mr. Hernandez?
Well, first let me introduce myself. I'm Brett Slocum, outside counsel, El Paso Electric, and I'll be putting on Mr. Hernandez as the next witness.
Thank you.
Could I ask that Mr. Wexler come back in the picture for just a minute? Because I have a question relating to Ms. Steve. Oh, thank you. Ms. Stevens, you never asked to move into evidence CLC Exhibit 9. Was that something that you wanted to do? You're on mute. Ms. Stevens, you're on mute. I don't think she can hear us.
I can hear you. I'm sorry. I got a little legend saying hit Control A and it didn't work. Yes, I'm sorry. I did very much mean to introduce that into evidence, and I meant to do what I started with her. If you would please.
Is there any objection?
No objection.
CLC Exhibit 9 is admitted.
Mr. Hernandez, would you raise your right hand?
Sure.
You solemnly swear the testimony you're about to give the matter up hitting should be the truth, the whole truth, nothing but the truth?
Yes.
Thank you.
Good afternoon, Mr. Hernandez. Would you please state your full name for the record?
Sure. My full name is Adrian Hernandez, A-D-R-I-A-N. Last name is H-E-R-N-A-N-D-E-Z.
Employed. Mr. Hernandez, can you hear me?
Yes.
Okay.
Yes, I can hear you.
And you're an employee? Okay, you're an
Oh,
employee
I'm
of El
sorry about
Paso
that.
Electric Company?
El Paso Electric Company, yes.
You have before you what has been marked as EPE exhibit number 55.
Yes,
Do you recognize that document?
I do. That is my direct testimony.
And that direct testimony also has exhibits,
Yes, sir.
and those exhibits are part of your testimony?
That's correct.
Do you have any corrections to your testimony or exhibits?
On my direct testimony, the only thing that was corrected was Exhibit AH6, which is the calculation of the PV3 proxy price. However, that was something that was revised or restated in my third supplemental testimony.
Okay.
Other than that, I have no changes on the direct testimony.
So just to be clear, the correct PV proxy price that El Paso is proposing is attached to your third supplemental?
That is correct.
Is your direct testimony that you prepared true and correct to the best of your knowledge?
Yes.
Was it prepared by you or under your direct supervision?
Yes, it was.
If I were to ask you the same question today, would you give the same answers under oath?
Yes.
Madam Hair Examiner, El Paso Electric offers EPE exhibit number 50 along with its accompanying exhibits.
You mean 55?
Yes, ma'am. I'm sorry. 55.
Is there any objection? EPE Exhibit 55 is admitted.
Mr. Hernandez, would you identify EPE exhibit number 56?
That is my first supplemental testimony.
And was that prepared by you or under your direct supervision?
Yes, it was.
Do you have any corrections to that testimony?
No.
It's true and correct to the best of your knowledge and belief?
Yes.
And if I were to ask you the same question today, would you give the same answers under oath?
Yes.
Madam Hair Examiner, El Paso Electric offers EPE exhibit number 56 along
Is
with
there
its
any
exhibits.
objection? EPE Exhibit 56 is admitted.
Okay, Mr. Hernandez, let's turn to EPE exhibit number 57. Could you identify that for the record?
Yes, that is my second supplemental testimony.
And it was prepared by you or under your direct supervision?
Yes, it was.
Do you have any corrections to your testimony, that testimony?
No, sir.
So it's true and correct to the best of your knowledge and belief?
Yes.
If you were asked the same question today, would you give these same answers under oath?
Yes.
Madam Hair Examiner, El Paso Electric offers EPE exhibit number 57 along with its exhibits.
Is there any objection? EPE Exhibit 57 is admitted.
Let's turn to EPE exhibit number 58. Mr. Hernandez, could you identify that for the record?
Yes, that is my rebuttal testimony.
Was it drafted by you or under your direct supervision?
Yes.
Do you have any corrections to that testimony?
No.
Is that testimony true and correct to the best of your knowledge and belief?
Yes.
And if I were to ask you the same question today, would you give these same answers under oath?
Yes.
Madam Hair Examiner, El Paso Electric offers EPE exhibit number 58 along with its exhibits.
Is there any objection? EPE Exhibit 58 is admitted.
And finally, Mr. Hernandez, would you identify for the record EPE exhibit number 59?
Yes, that is my third supplemental testimony.
Was it drafted by you or under your direct supervision?
Yes, it was.
Do you have any corrections to that testimony?
No, I do not.
So it's true and correct to the best of your knowledge and belief?
Yes.
And if I were to ask the same question today, would you give the same answers under oath?
Yes.
Madam Hair Examiner, El Paso Electric offers EPE exhibit number 59 along with its accompanying exhibits.
there any objection? EPE Exhibit 59 is admitted.
At this time, we tender Mr. Hernandez for cross-examination.
Ms. Stevens, you're up and you have 30 minutes.
Thank you. Good afternoon, Mr. Hernandez. I'm Anastasia Stevens for the City of Las Cruces, and you guys are wearing me down, so I only have a few questions for you. And I think that probably, tell me if I'm wrong, because there's so many, moving pieces, but I think that probably the best place to start for these questions, which are fairly generic, is your third supplemental testimony, because that's the most up to date. Could you turn to table AH13S on page 7 of Exhibit 59?
Could you tell me the page number again?
7, page 7. It's 9 on the PDF. Page
Okay,
7 on the bottom.
Okay.
Very generally, when you calculate the base rate revenue deficiency, and at this point, post rebuttal, the company is at 5 million, an increase of $5,139,238. That I think it's $475,000 reduction in other miscellaneous charges. Does that have the effect of increasing the base rate revenue deficiency or decreasing that?
It's not necessarily increasing base revenue. It's reducing total revenue, but base revenue is its own category. So in my rebuttal testimony, I show the total increase, and there is where you would see that other revenue decrease. This here is just isolating the base rate revenue increase, the 5.1 million.
Did you say 5.1 million?
Yes.
Thank you.
Well, let me put the question slightly differently. If EP had proposed no changes to its miscellaneous tariffed revenues, would that base revenue deficiency be would it be 4 million? Don't have my calculator in front of me. Would it be $475,000 less or more?
Yeah, so the total revenue increase would be 5 million if we didn't include the decrease to the other. If that was a $0 increase, the other revenues, then the base rate revenue deficiency would match the total revenue deficiency.
Well, I'm not talking about, well, I think that let me go a little farther with this. Is that change in miscellaneous revenues, miscellaneous fees reflected in line 13 on this table AH13S?
Yes, ma'am, it is.
So if you had held those charges steady, would the base revenue deficiency be low? It would be lower, would it not?
I'm a little confused. So if we held the charges on line 13 steady, that would include the reduction, the 400.
I'm sorry, sir. If we held the charges on
line 13,
yeah.
If we held those steady, that of course includes the reduction to the other revenues. So you're saying if we don't include it, is that what I'm understanding?
If you had not proposed the changes that generate those reductions to tariffed other operating revenues, would the base revenue deficiency that from which all the rates are, the base revenues are developed, would that deficiency be slightly smaller?
No, because you have to look at it on the overall basis. So I think it would help if we look at Schedule AH1. I think that would show you how we start off with the base period, and then we move to the adjusted, and then we get to the test period. So between those three levels, we actually account for all that. So just looking at this table by itself, it does seem that way. But if you look at the whole picture, I don't believe that's the case.
And are you familiar with the actual application covering document that the company filed in this case? I'm afraid it's not in evidence, so I'm just asking you. If you're not, we'll just stop here.
I don't think I am, no.
Well, let's move on. What I really wanted to ask you about, Mr. Hernandez, is not surprisingly the Palavieri, the two aspects of the Palavieri proxy price. First, how you get to that proxy price, why you get to that proxy price, and then the alternative cost of service calculation. And again, I think that what you said earlier, as you were making the corrections to your direct testimony, is that the right place to look for the proxy price calculation is here at Exhibit AH. Is it AH13S? Correct.
That's correct.
Of your third supplemental.
Yes, ma'am.
This is the one that you're standing by, correct?
Yes, ma'am.
And conceptually, you've used the basically the rate base, return on rate base, and all the cost of service relating to Palavieri units 1 and 2. Is that right?
That's correct.
Why did you not use units 1, 2, and 3?
Unit 3 is not in rate base. That cost is actually removed from the cost of service. So the best equivalent that we could use are units 1 and 2.
And unit 3 is in the Texas rate base. Are the Texas numbers so different that there would be a material difference in the cost of service calculation if you had lumped all 3 units together as you do in Texas?
I believe there would be a difference, yes. In fact, one of the main differences between New Mexico and Texas is that our New Mexico cost of service completely moves out Palo Verde Unit 3.
But setting aside the moving out Palo Verde Unit 3, are there differences in the way that you determine the rate base for all 3 units in Texas that are either numerically or theoretically different from how you did it here, reflecting units 1 and 2 in New Mexico?
I think it would be different compared to PV units 1 and 2 within the New Mexico cost of service. I don't know the specifics about how it's valued, for example, in Texas. So I don't want to speculate, but I think the most equivalent measure is units 1 and 2 in the state of New Mexico.
And forgive me for not knowing exactly what your role at the company is, because I know we've come across it another few times over the years. But do you have any role in you just use the term how things are valued. Do you have a role in valuing assets, or is your role in doing these cost of service studies with the booked numbers?
That is correct. Yeah. So I believe Mr. Hancock would be the one that would do the valuing of the PV units.
So all the figures here on page 2 of AH13S, and even on page one of two, they come from other witnesses and other sources. Is that right?
They come directly from the cost of service after they've been adjusted. So these are all test year numbers.
And are you the one who has the judgment to make adjustments in test year numbers, or are other witnesses responsible for those?
Yeah, I don't sponsor the adjustments made to plant, for example. No.
Gotcha. I understand. So going to a more broad philosophical standpoint, Mr. Hernandez, has EPE, to your knowledge, ever tried to sell the interest in Palo Verde 3 that it has been voluntarily using to serve New Mexico customers for something like 30 years?
Not that I know of. I think that would be more of a question for Mr. Schichtel or Mr. Barachik. I'm not sure about that.
And do you know anything about the marketing of power and energy in the
Not
public
really.
markets?
That would be more Mr. Barachik, I believe.
Do you have an opinion as to whether, if the company were to try to market Palo Verde 3, this sort of analysis of its basically historic embedded costs for the unit would have a bearing on the price that it could obtain for that I don't want to call it asset because it implies something physical, but that interest, that
I mean, no, I really couldn't tell you. I mean, I know that, especially since I'm looking at things historically, if you're looking at forward-looking and how it would be on the market, I really couldn't speculate how, for example, natural gas prices would change and things like that. So I don't think I'm the right person to talk about that.
Well, setting aside the natural gas prices, the page 1 of 2, on the page 2 of 2, where you're actually developing sort of a mini cost of service. Would that be fair to say?
Yes, that's correct.
Do you think that mini cost of service approach would get EPE very far if they were marketing this particular chunk of Palo Verde to a third party?
Your Honor, I think it's been asked and answered.
Sustained.
Did you say mini cost of service?
Mini, M-I-N-I.
Thank you.
Miniature. Okay, Mr. Hernandez, let's talk about the alternative cost of service that you've developed based on assuming that Palo Verde 3 is not used to serve New Mexico. And I know that's buried in one of your schedules, so I just want to ask you some questions. Have I lost the witness? Oh, he's not. I'm getting a big view of the court reporter and Mr. Hernandez's team.
I'm here.
There you are. Thank you. Now I see you. So your alternative cost of service, Mr. Hernandez, what assumptions did you make other than that? Well, the idea is to eliminate the New Mexico's use of Palo Verde 3, correct?
So this is actually a good question. So I think in my testimony, I think in rebuttal testimony, I make it a little more clear that I'm not changing anything in the cost of service that we're filing. The only thing that's changing is our allocators. Those allocators that are provided to me by EPE witness Novella, Mr. Novella. But everything else is staying the same. Everything else is staying equal because we're already removing PV Unit 3 in our cost of service. So it's just the allocation of everything else.
Okay. And so you've made no changes other than what the other witnesses have done in terms of making any compensations for other contributions that New Mexico makes to the operations, such as the renewable portfolio standard solar. You haven't touched anything like that, is that right?
That's correct, because I really wanted to show the impact of just simply the allocation difference without having anything else change.
I appreciate it. That's all my questions. I thank you very much, Mr. Hernandez.
Thank you, ma'am.
Mr. Herman, you're next and you have 20 minutes.
Thank you, Madam Examiner. I have nothing for this witness at this time, so I will pass him.
So Mr. Smith has 10 minutes, and I know he's not available today. But he didn't say when he brought this up, when he brought up his not being available today, he only brought it up in connection with his cross-examination of Mr. Novella. Maybe if Mr. Wexler could come on screen. I'm wondering if Mr. Wexler, if he recalls, if Mr. Smith said anything about his cross-examination of Mr. Hernandez?
He did not mention it specifically to me, even outside of the record. So I just don't know.
Okay, well, I'm just going to say he waives his cross of Mr. Hernandez. Ms. Drake reserved 10 minutes, but she's not present, so she waives her cross-examination. Mr. Bagatko, you have 15?
Yes, Madam Hearing Examiner, thank you. Good afternoon.
Madam Hearing Examiner, I'm sorry, I thought I reserved 10 minutes.
You're correct, you did, I'm sorry. So let's go back to Mr. Simpson.
Thank you. Good afternoon, Mr. Hernandez. My name is Philip Simpson. I'm a pro se intervener in Las Cruces.
Good afternoon.
I just have a couple of questions. Well, let's go to EPE Exhibit 55, your direct testimony, page 21.
(21) of the testimony or of the PDF?
21 of the testimony.
I'm there.
Okay, and I'm looking at I'm sorry, my reference doesn't seem to be right. Hold on just a second, please. My apologies, I wrote down the wrong reference. If you'll give me just a moment, I think I can find it. Yeah, I'm sorry, it's page 22, line 3. It says Schedule K1 itemizes all the rate base amounts and presents the jurisdiction.
I'm sorry, please.
I'm sorry, Mr. Lee. When I started reading that, I realized I was speaking too fast. I'll start over. Schedule K1 itemizes all the rate base amounts and presents the jurisdictional allocation of each amount along with the allocator that was applied for the allocation. A description of each imported and dynamic jurisdictional allocator and how each was derived is presented in Schedule M1. And I had a couple of questions about those allocators in M1. I guess First, I'd like to go to Schedule K1. So that's in El Paso Exhibit 58, PDF page 75 of 89.
What was the PDF page again? I'm sorry.
Page 75 of 89 in EP 58. I'm looking at line 27. There's an allocator there called RGPROD labor, LABOR. And when I look at M1, I can't find that allocator.
Okay.
We can go to M. I can take you to M1 if you like.
Yeah, let's go to M1. I believe should be there.
Okay, so let's see. To get to M1, let's go to EPE Exhibit 01.
Okay.
And PDF page 96 of 313.
And Mr. Simpson, what page of Schedule M1 are you on?
So it says Schedule M1, page 1 of 2, but this is the second occurrence of Schedule M1, page 1 of 2. There's actually 4 pages that are labeled similarly.
Okay.
So yeah, this is the page where it should be found, I think.
Yes.
And I was looking at a slightly different version of this, but I couldn't find it on that version, and I'm not seeing it on this version either. Again, it was RG_prod labor.
Yes. I need to see if we go back to the schedule. I just want to make sure because that line you referenced was a $0 value. But I believe, I just want to verify that if there was a dollar amount assigned to it, then it should be on this schedule here. But it does look from what I see and from what you pointed out that it is missing from this schedule. But I can explain to you what it is, and I can tell you how it is set up, if that helps.
Sure. Yes, please.
So the RG prod labor allocator it was created so that it would capture both.
Sorry, RG prod labor what?
Allocator.
Thank you.
Sorry about that. It is the Rio Grande production labor allocator. So because Rio Grande has both steam units and a turbine unit, something that would be classified as other production, what we would consider a peaking unit, they have 2 different allocators. And I do talk about that in my testimony. One of them is allocated using a 4CP A&E allocator. In the cost of service, it shows up as D1 prod.
I'm sorry, one of them is allocated using say it slowly.
Yes, sir. 4CP A and E allocator.
Go ahead.
And it is identified as D1 prod in the cost of service. The other one, the one for peaker units for Rio Grande 9, is the D2 prod, which is a 4CP allocator. the RG prod labor allocator is a combination. It's a dynamic allocator, which takes the allocation of both of the labor cost of both the steam units and the other production unit to combine the allocation. So in other words, it's combining both the D1 and the D2 prod, the results of that, to come up with an allocator.
Okay, so would it be correct to say then that you can't really list a set value for this particular allocator because it is a dynamic allocator?
No, it should be in the schedule. I apologize for the fact that it's not in there. It is also presented in detail in the cost of service model. And there you could even see how it's set up and what accounts it's picking up.
I'm sorry to interrupt. Can you be more specific about the cost of service model and where I could find that?
Sure. Within the cost of service model, otherwise known as work paper K, there is a dynamic allocator tab within that Excel model. In there, you would see how the RG prod labor allocator is set up using some of these Rio Grande labor accounts that I was mentioning earlier. It would also be summarized in the allocator tab. It would just be more on a summary detail, kind of like Schedule M1.
So you said work paper K. Is that the same as, excuse me, as Schedule K?
Well, there's various K schedules. Work paper K is the cost of service model that pretty much feeds all the K schedules. I believe we have K1 through K8. So we have 8 different schedules.
Okay. And I'm sorry, that work paper K Excel model, was that something provided in Discovery, or is that in one of your exhibits?
That was provided in Discovery. The cost of service model was labeled as confidential because it was proprietary. However, access was given to anybody who requested it. I believe they just had to sign an affidavit or a waiver or something to get access to it.
Okay. Yeah, I believe I've seen that. So let me go back.
Mr. Simpson, your time's up.
Okay. Thank you.
Yes, sir.
Mr. Bagatko, you have 15.
Thank you, Madam Hearing Examiner. Good afternoon, Mr. Hernandez.
Good afternoon.
I trust I'm coming through loud and clear.
Yes, sir.
All right, thank you for that. Let me get some of my stuff pulled up here. All right, then I'm going to direct your attention first to EPE exhibit number 57, which is your second supplemental testimony. I'll give you a moment to get there. I'm looking at page 5, Mr. Hernandez.
What page?
Page 5.
Thank you.
You're welcome.
Okay, I'm there.
Now, in your second supplemental testimony at page 5, line 5, you reference the base rate revenue amount of $120,828,995. Do you see that?
Yes.
All right. And I understand, based on the footnote appended to that figure, that that amount does not include non-firm revenues. Is that correct?
That is correct.
All right. Now we're going to shift over to your rebuttal testimony, which is marked as EPE exhibit number 58. And I would direct your attention to page 4. I'll give you a moment to get there, Mr. Hernandez.
Thank you. Okay, I'm there.
Specifically, I'm interested in table AH1R. Do you see that there on page 4?
Yes, sir.
And you see down there in your table where it reflects base rate revenue of $120,974,734.
Yes, sir.
That's marked as including non-firm revenues, correct?
Yes, sir.
So the revenue from table AH1R was used to compute the New Mexico revenue deficiency. Is that correct?
I'm sorry, was used to.
Was used to compute the New Mexico revenue deficiency. Is that correct, Mr. Hernandez?
Yes, just to be specific, the total revenue deficiency.
Okay.
This table here is showing the total revenue deficiency of 4.6 million.
All right.
The hearing examiner, however, did ask me to, in a bench request, to specify again what the base rate revenue was. And so in my third supplemental testimony, I further break down what the base rate revenue requirement is.
Thank you. And I remember that, and I thank you for that direction. Trying to stay focused here, though, on what we're talking about in terms of what I saw in EPE Exhibit 57 and what we see now with Table AH1R and EPE 58. Can you explain why non-firm revenues were included in your rebuttal calculation, keeping in mind that they were not included in the calculation we just discussed in EPE 57? I hope that's clear enough for you, Mr. Hernandez. If not, please let me know.
Yeah, I think I can make it clear. I think the better comparison would be to compare my direct testimony to my rebuttal testimony, because those tables are very similar. And then the second supplemental testimony could be compared to my third supplemental testimony, so that we're on the same basis, right? So one of them is getting to the base rate revenue requirement, and the other, the direct testimony and this testimony that we're looking at now, is talking about the operating revenue deficiency, which is the total deficiency.
Well, do you think that'll answer my question about why non-firm was included in one and not the other?
Yes, sir. So on one of them, I was just trying to get to the firm base rate requirements. So in the cost of service, I'm only presenting in the, if you look at the class cost of service, I'm only showing the firm rates. I don't consider the interruptible rate in there. That's not a firm rate. So there's a difference there. So when I'm showing total revenue, I do include the non-firm revenues just to get to the total number. But when I'm trying to get to that base rate revenue requirement and what I'm determining in the cost of service for just the base rates, the firm rates, I exclude them.
All right, well then, just so maybe I can tie up some of these threads, can you confirm then which base rate correctly reflects the increase that EPE is seeking?
Yes, sir. If we go to my third supplemental testimony,
all right, I'm there.
okay, there we go. On page 7.
Yes, sir.
This one here starts from from rate base, and it shows a return, and it gets down to line 12, which is the total cost of service, which would be in other words, the total revenue requirement. And then from there, I break down individually the other revenues that are removed to get to the base revenue requirement. Included in line 13 is non-firm revenues. So essentially the cost of service, the purpose of the cost of service is to get to the base rate revenue deficiency.
And to be clear, we're talking about table AH1 3S that's included on page 7 of EPE 59, correct, Mr. Hernandez?
That's correct, sir.
All right, thank you for that.
You're welcome.
Moving along to your direct testimony, which is marked as EPE Exhibit 55. I'm specifically interested in talking about something on page 50. I'll give you a moment to get there, Mr. Hernandez.
Thank you. Okay, I'm there.
All right, well, there on page 50 of your direct testimony, I'm looking at lines 2 through 7, where you state essentially that in case 18-00006-UT, you were directed to address monthly variability in the FPPCAC as an issue in this case. Is that
Sorry.
correct?
I think I'm looking at the wrong page.
Okay.
Was it page 50 on the PDF?
Page 50 as numbered in your testimony, which would be page 52 in the PDF format. I apologize for that confusion.
Okay.
Mr. Bagatko, I think what you were just reading from is actually page 51 of his testimony at lines 4 to 6.
Ha, you're correct, Madam Hearing Examiner. Thank you for that catch.
That makes more sense. Okay.
I'm sorry.
Thank you.
All right, so we were talking about lines 2 through 7 on page 51 of your direct testimony. And you were talking about what you were doing in terms of case number 18-00006-UT. Do you recall that?
Yes, sir.
And one of the things you were supposed to do as a consequence of that case was to address monthly variability in the FPPCAC as an issue in this case, correct?
That's correct.
All right, well, keeping that in mind then, I believe on page 52, and let me make sure my numbering is correct, lines 1 through 13 of your direct testimony, you propose a 12-month rolling average to collect fuel and purchase power costs now. Is that correct?
Yes, that's correct.
Do you believe that this new approach is more accurate than the current approach, which I believe consists of a 2 months prior actual costs?
I'm sorry, Mr. Bergatko, you've gotten fuzzy. Do you believe that this?
Do you believe that the approach that the 12-month rolling average approach that you're proposing in this case regarding the FPPCAC is more accurate than the approach that is currently approved by the commission, Mr. Hernandez? I hope that came through clearly.
Yes, I understand. It's hard for me to say accurate because the current way that we handle FPPCAC, it takes into account fuel costs from 2 months prior, only from 1 month. So you could say that it's a more recent cost. However, because it's so volatile, fuel prices from month to month are so volatile, especially these last couple of years, the 12-month average would actually smooth out that month-to-month volatility and not make such a drastic impact on customers' bills. So you could argue that the current setup is actually more accurate because it's more recent, but I don't think it's actually that accurate if you're going to see that month-to-month volatility that we've been seeing, if that makes sense.
It does. And so in terms of the goals behind what's been proposed in this case, you're submitting it more in terms of amelioration rather than accuracy in tracking those costs?
I think it's still accurate to have a rolling 12-month average. You're just limiting that impact from month to month. If you have, I believe it was mentioned previously in somebody else's testimony that there was some months where we had negative gas expense. We were paid to take gas. So that kind of scenario would really impact the fuel cost from month to month. Having a 12-month rolling average would, like I said, smooth it out and reduce those types of impacts.
Mr. Hernandez, do you know if input from customers has prompted the proposal of the 12-month rolling average in this case, or is it something else?
from my perspective, I only know about it from this prior case, the fuel continuation filing, docket number 18. But I would imagine that it is something that comes up with customers. I mean, even friends of mine have asked me. So it's definitely something that I'm sure we've taken into consideration as well.
Thank you for that, Ms. Hernandez. I have nothing further, Madam Hearing Examiner, and I thank Mr. Hernandez for his time today. I'll pass the witness.
Judge, you're on mute.
My husband was on the phone, so that's why I muted myself. Mr. Hernandez, I just have one question for you. I think I know the answer to this, but I just want to make sure. Would you turn to page 7 of your third supplemental testimony?
Okay.
Okay. So if I am telling the commissioners the amount of EPE's requested base rate revenue, am I correct that the number I start with is on line 16? The 120 million number?
Yes, ma'am. I think I see what you're saying. So yes, that would be the as adjusted base revenue number. Mr. Carrasco could explain this better, but he does, he takes our base period revenues, base revenues, and he does annualization adjustments. And so yes, that would be the starting point. That's correct.
Okay, thank you. So I don't want to go longer than an hour and 45 minutes without a break. So Mr. Slocum, do you have any redirect?
Yes, I have a few questions for redirect.
Okay, then that might take us beyond an hour and 45 minutes. So I think I'd like to go ahead and take our break now.
Okay.
So let's come back at 2:20.
Okay.
David, are you ready?
Yes, Your Honor.
Okay, let's go back on the record. Oh, looks like Mr. Hernandez stepped out for a minute.
I'm back. Sorry about that.
Okay. Okay, Mr. Slocum, you have 10 minutes.
I can't.
I can't hear you.
Can you hear me now?
Yes.
Yeah, I'm sorry about that. Mr. Hernandez, if we could go back where the ALJ hearing examiner last referred you to page 7 of your third supplemental testimony. And once you present table AH1-3S, and Ms. Stevens, they also asked you questions about this. And in your response to particularly Ms. Stevens' questions, you made a distinction between the total increase and the base rate increase. Could you explain what the difference is in that?
Yes, sir. You know, I actually think it would be very helpful if we go to EPE Exhibit 58, which is my rebuttal testimony, and if we go to PDF page 33.
Could you give me the actual page from the testimony?
The actual page, it's the work papers after the testimony. So it's not part of the actual testimony. It was in the PDF. It includes work papers after the testimony. It doesn't have a page number because it's just a single page. It's page 1 of 1.
And how's it titled?
Yes, it's titled Work Paper Exhibit AH1R. And on the left-hand side, it's Schedule A1 based on the rebuttal adjustments that were made.
I'm sorry, could you repeat the PDF page again?
Sure. Page 33.
Okay, I found it.
Okay, you can continue, Mr. Hernandez.
Okay, so I think this might make it a little more clear, especially since this is the file that I use to prepare both of those tables in both my rebuttal and in my third supplemental. I'm just going to zoom in a little bit. Give me a second. Okay. So on line 1, if you go all the way to the far right where it says test year period, that right there, the 125,968,000, that is our requested base revenue. In between that one, I'm going to say the column numbers, column B and column F. In between that, you see column E. That shows the base revenue increase. And then if we go down to line 9, that shows that 4.6 million that we were discussing in my rebuttal testimony, which is the total revenue deficiency.
In that column E on line 8, other operating revenues, there's a number of 474,634 in negative. What is that?
Yes, sir. So that is the number that Ms. Stevens was referencing. And that is a $474,000 decrease to miscellaneous revenues that Mr. Carrasco is proposing. It's being reflected here.
And EPE is requesting approval of those miscellaneous revenue, the reduction in those as well?
Yes, sir. And that's why I think initially we were trying to show that even though the base rate increase was a certain amount, in total it was less because of that reduction to miscellaneous revenue.
So the net increase you're requesting shown on line 9 there?
That's correct.
Okay. That's all the questions I have.
staff and interveners, if you have any recross, would you raise your hand, please? Okay. Thank you very much, Mr. Hernandez. You're excused.
Thank you.
EPE, you may call your next witness.
Good afternoon, Madam Hearing Examiner. This is Carrie Olson. I'll be doing the next witness, and it's going to be Mr. Carrasco, I believe.
Okay.
Is that okay with you?
Yes.
And it'll just take us a minute to switch out the witnesses in El Paso.
Sure.
Miss Olson, is it Olson?
That's correct.
Judge, you're on mute.
Are you ready, Mr. Carrasco?
Yes, Hearing Examiner. Yes.
Okay. Ms. Olson, go ahead and start.
Mr. Carrasco, would you raise your right hand, please? You solemnly swear the testimony you're about to give in the matter not pending will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
Good afternoon, Mr. Carrasco. Can you hear me okay?
Yes, I can. Good afternoon.
Can you please state and spell your name for the record?
Manuel Carrasco. First name is Manuel. Last name Carrasco is Carrasco.
And Mr. Carrasco, what is your current position at EPE?
I'm the manager of the rate research department.
And I believe you have several exhibits in front of you, either electronically or paper copy. I'd like to start with what's been marked as EPE Exhibit 60. Do you have that in front of you?
Yes, I do.
And do you recognize that document?
Yes, this is my direct testimony filed in this proceeding, filed in May 2020.
Was that direct testimony drafted by you or under your supervision?
Yes, it was.
And under the table of contents, there's a list of 5 exhibits. Are those exhibits identified as part of your direct testimony?
Yes, they are.
And do you have any corrections to your direct testimony?
Yes, I do.
Can you please walk us through that correction?
On page 78, line 5, the dollar amount of $16, it should be $10.75.
And with that correction, is the direct testimony that you prepared true and accurate to the best of your knowledge and belief?
Yes, it is.
And if you were asked those same questions stated in that pre-filed testimony today under oath, would your answers be the same?
Yes, they would.
Madam Hearing Examiner, El Paso Electric offers EPE exhibit number 60 along with accompanying exhibits.
Is there any objection? EPE Exhibit 60 is admitted.
And Mr. Carrasco, do you have before you what's been previously marked as EPE exhibit number 61?
Yes, I do.
And what is that exhibit?
That's my rebuttal testimony, also filed in this proceeding, and it was filed November 6, 2020.
And was that rebuttal testimony drafted by you or under your supervision?
Yes, it was.
And on the table of contents, there's 3 exhibits listed. Are those exhibits part of your rebuttal testimony?
Yes, they are.
And do you have any corrections to your, excuse me, Madam Hearing Examiner, Mr. Carrasco had identified a couple of additional corrections. How would you like us to handle that?
Oh, that weren't uploaded?
Mm-hmm.
Go ahead and go through those, and then this evening, replace the version that you uploaded with one that has these additional corrections.
Okay, thank you. Mr. Carrasco, do you have any corrections to your rebuttal testimony?
Yes, I do.
And can you please tell us what that correction is?
It is in the table of contents, under the exhibits descriptions. The page number in the last 2 exhibits listed on there are transposed. So for exhibit MC3R, instead of page 4, it should be page 12. And then on exhibit MC2R, instead of page 12, it should be page 4.
Okay. Did you have any other corrections to your rebuttal testimony?
No.
And with that correction, is the rebuttal testimony that you prepared true and accurate to your knowledge and belief?
Yes, it is.
And if you were asked those same questions here today under oath, would your answers be the same?
Yes, they would.
Madam Hearing Examiner, El Paso Electric offers EPE exhibit number 61.
Is there any objection? EPE Exhibit 61 is admitted.
And Mr. Carrasco, do you see exhibit number 62 in front of you?
Yes, I do.
And what is that document?
That's my supplemental testimony filed in this proceeding, and it was filed in December 17th, 2020.
And was that supplemental testimony drafted by you or under your supervision?
Yes, it was.
And do you have any corrections to that supplemental testimony?
Yes, I do.
And what are those corrections?
Yes, on page 1, line 20, The year 2021 should be 2020 in that line.
Okay, and do you have any other corrections?
No, I don't.
With that correction, is the supplemental testimony that you prepared true and accurate to the best of your knowledge and belief?
Yes, it is.
And if you were asked those same questions today under oath, would your answers be the same?
Yes, they would.
Madam Hearing Examiner, El Paso Electric offers EPE exhibit number 62.
Is there any objection? EPE Exhibit 62 is admitted.
And Madam Hearing Examiner, that's all of Mr. Carrasco's testimony. As you'll recall, EPE had filed a motion and you had granted the alternative relief allowing Mr. Carrasco to adopt the pre-filed direct, rebuttal, and first and second supplemental testimonies pre-filed by Mr. Julio Aguirre, and as part of your order, had allowed Mr. Carrasco to identify certain non-substantive portions of that testimony that he would not be adopting on the stand. So I was intending to ask Mr. Carrasco at this time to identify those sections.
Go ahead.
Okay. So Mr. Carrasco, starting with EPE 63, which I believe is Mr. Aguirre's direct testimony, can you please identify the non-substantive portions of that direct testimony that you are not adopting today?
Yes, it is. It's the section 1 of testimony.
Okay. And Mr. Carrasco, did you have any other additional corrections to Mr. Aguirre's direct testimony?
Yes, I do.
And can you please identify those corrections?
It is on page 37, line 8, in that table. Instead of 6 p.m., it should show 7 p.m.
Okay. Madam Hearing Examiner, would you like us to go through all of the testimonies or do them piece by piece? How would you like us to proceed?
You're on mute.
Are you asking if I want you to move them in one by one or all together?
Yeah, if you'd like me to identify the pieces he's not adopting of each piece of testimony and move admission of that piece of testimony, or if you'd like me to do it, identify it in all of the testimony and then move it all together.
The former, one by one.
Okay. And I apologize, this is the first time I've done this where someone's adopting it on the stand. Because you've already granted the motion allowing him to adopt it, should I just move for the admission of the testimony adopted by Mr. Carrasco?
I think I would ask him if he's adopting it.
Okay. Mr. Carrasco, are you adopting the exhibit 63, the direct testimony of Mr. Aguirre?
Yes, I am.
Madam Hearing Examiner, we would move for the admission of EPE exhibit 63, the direct testimony of Mr. Aguirre adopted by Mr. Carrasco.
Is there any objection? EPE Exhibit 63 is admitted.
Okay, moving on to exhibit EPE exhibit 64. Mr. Carrasco, do you have that in front of you?
Yes.
And this is the supplemental testimony of Julio C. Aguirre. Is that correct?
That's correct.
And Mr. Carrasco, can you please identify the non-substantive portions of Mr. Aguirre's testimony that you are not adopting?
It is section 1 of the testimony.
And that's page 1, lines 1 through 12, is that correct?
That's correct.
And did you have any additional corrections to Mr. Aguirre's supplemental?
No, I don't.
And Mr. Carrasco, are you adopting today EPE Exhibit 64, the supplemental testimony of Julio C. Aguirre?
Yes, I am.
And Madam Hearing Examiner, El Paso Electric offers EPE Exhibit number 64 adopted by Mr. Carrasco.
For any objection? EPE Exhibit 64 is admitted.
And Mr. Carrasco, do you see EPE Exhibit number 65, the rebuttal testimony of Julio C. Aguirre?
Yes.
And again, can you please identify non-substantive portions of Mr. Aguirre's rebuttal testimony that you are not adopting?
That will be section 1.
And again, that's page 1, lines 1 through 12, is that correct?
Yes.
And do you have any additional corrections to Mr. Aguirre's rebuttal testimony?
Yes, I do.
And can you please identify those corrections?
On page 30, line 4, the amount 1080 should be 1088.
And did you have any other corrections to that testimony?
No.
And Mr. Carrasco, are you adopting the rebuttal testimony of Julio C. Aguirre today?
Yes, I am.
Madam Hearing Examiner, El Paso Electric offers EPE Exhibit number 65 adopted by Mr. Carrasco.
For any objection? EPE Exhibit 65 is admitted.
And finally, Mr. Carrasco, do you have before you EPE Exhibit 66, the second supplemental testimony of Julio C. Aguirre?
Yes.
And Mr. Carrasco, can you please identify non-substantive portions of Mr. Aguirre's second supplemental that you are not adopting?
That'll be section 1.
And is that page 1, lines 1 through 15?
Correct.
And Mr. Carrasco, do you have any additional corrections to Mr. Aguirre's second supplemental?
I do not.
Mr. Carrasco, are you adopting EPE Exhibit number 66, the second supplemental testimony of Julio C. Aguirre?
Yes, I am.
And Madam Hearing Examiner, El Paso Electric offers EPE Exhibit number 66 adopted by Mr. Carrasco.
For any objection? EPE Exhibit 66 is admitted.
And at this time, we tender Mr. Carrasco for cross-examination.
Okay, Ms. Stevens, you have 2 hours, and we will take a break probably in about an hour.
Okay, I hope I do not take that long, Madam Hearing Examiner. And good afternoon, Mr. Carrasco. How are you?
Good afternoon. I'm fine. Thank you, Ms. Stevens.
You know, I'm Anastasia Stevens for the city. And I would like to very quickly start with your the change you made, your rebuttal testimony, the 2 exhibits that you changed the pages of.
Yes.
And Madam Hearing Examiner, I think I intended to do this yesterday and probably failed to, but the city would ask that administrative notice be taken of that entire report rather than just the 2 pages that are Mr. Carrasco's exhibits.
Hold on, let me get there.
Yeah, it's 61. You say I saw that.
I'm getting there. Ms. Olson, any objection?
Hearing examiner Glick, I'm not sure that those full reports are in the records. So I'm not sure how the hearing examiner would take administrative notice of the full report.
They were filed in the commission at the commission on June 1st of 2020, and I think I may have already made this request, Madam Hearing Examiner, but it's been quite a haul here. But they under the rule on administrative notice, you may take administrative notice. If you need copies, I can find copies. But they are very easily accessible in the record of case number 1800116 UT filed on June 1st of 2020.
Okay. Ms. Olson, do you object?
I don't object to the fact that there are documents on file by the commission that EPE has filed.
Well, if I take administrative notice, documents for which administrative notice is taken come into evidence and have the same effect as other information admitted as evidence.
Madam Hearing Examiner, I don't think we have any objection to that.
Okay. Okay, so Ms. Stevens, I can find these by going to eDocket and searching for filings on June 1st, 2020.
And my way of finding it is through case 1800116 UT. It may be locatable, 2 or 3 different ways because it's a rule filing as well as a case docket filing, and obviously it was filed on a date. And I'm quite certain it was June the 1st because I did intend to ask administrative notice of it earlier.
Okay, I'll be right back. I want to get my rules. They're in the other room.
I'll confirm that date right now.
Okay, I will grant the request to take administrative notice. I do want to read a provision of our procedural rules that I find is frequently not complied with. And this is rule 1.2.2.35 D as in dog 3. Parties and staff requesting that administrative notice be taken of documents or portions of documents or of the contents thereof must submit those documents or portions of documents to the commission or presiding officer in the form of exhibits, except as may be otherwise provided in this rule. So I'm going to forgive the non-compliance in this case, but and unless you're requesting that I take administrative notice of a voluminous document, I do enforce this rule. So if you're going to request that I take administrative notice of a document that's not hundreds of pages long, you need to provide it in the form of an exhibit.
Thank you, Madam Hearing Examiner. It's 155 pages. And that was just my oversight. I may have had it on a list somewhere. I may even still have it on my list. But thank you very much. And Mr. Carrasco, in this case, the company is proposing to increase customer charges up to 100% of what the company considers to be the fully allocated cost of providing customer services. Is that correct?
It's 100% of customer-related costs.
And when you reduced your cost of service request in the company's rebuttal testimony, did you reduce the customer charges, proposed customer charges to reflect that change across the board?
Yes, there was an adjustment to them, and I know for a fact that residential customer charge was reduced by 11 cents.
And with that 11 cents reduction, is the company still asking for 100% of its identified customer-related charges from residential customers?
Yes, it is.
And what percentage increase are you asking of residential customers for the customer charge?
It's about 50%.
Did you say 150?
No, I said it's about 50%.
Thank you.
And now for some other classes, you did not propose increasing all the way up to 100% of the company's identified customer charges. Is that correct?
That's correct.
And my understanding is that was a judgment call on the company's part?
Yes.
And would that be you or Mr. Aguirre or both of you or higher levels than that?
Yeah, that was on Mr. Aguirre. But of course, I was his manager, so I know what was going on.
You take the fall, huh? So when you apply judgment in that case, you're aware that in some cases the customer charges increased by tens or even hundreds of dollars per month for some of the classes?
Yes, I'm aware of that.
And are you, in your experience, and I know you've been doing this a very long time, Mr. Carrasco, are you aware of any time in which EPE has ever proposed such substantial increases to customer charges in one single case?
I can't recall the percentages themselves, but I know like in the last EP's last rate case with the PRC, we did also ask for a significant increase in customer charges.
Do you recall it being this significant?
I can't remember the percentages.
And has the commission, the PRC, ever approved such, substantial increases in one fell swoop for new EPE?
No, in fact, I know that they kept, and I'm the one that really comes into mind is residential, of course. And I know the commission kept it at $7. So that means that the customer charge for residential is over a decade old. So it's really misaligned with cost. So that's why we're proposing a increase.
And you're talking about case 15-1000127 UT, are you not?
Right.
And in that case, do you remember that there was the net outcome of the rate case was a $1.1 million increase to EPE's revenue requirement?
Yes, it was one something, yes.
Yeah. And was that entire revenue increase allocated to the residential class?
Yes, it was.
But it was allocated to the residential class, but to the energy charge component, not to the customer charge component. Is that right?
That's correct.
Moving on from customer charge. Oh, before I move from customer charges, before you propose some of these really huge customer charge increases including hundreds of dollars for, NMSU and even for city and count for the water pumping, the city's rate number 8, it goes from $20 to $50 for each well. Did you confer with any of the customers who would be affected by those changes?
Oh, no, we didn't. But those new updated customer charges that we're asking for non-residential customers are pretty much in line, as Mr. Aguirre presented in his testimony. They're in line with other utilities here in New Mexico.
And is that with respect to the residential class or with respect to all of the other rate classes for whom you're proposing increases?
It's with respect to the non-residential classes that you mentioned earlier.
The non-residentials. Did you make a comparison? I know you at this point means you and Mr. Aguirre, but did you, before you chose those customer charges, let's do this separately for residentials and for everybody else. Before you selected and proposed the customer charges, did you compare them to other electric utilities in New Mexico for corresponding rate classes?
Yes, I know that Mr. Aguirre included a comparison in one of his testimonies.
That was for residential or for
residential and for non-residential. So there's comparisons in the testimony.
And do you know what rate of, the trajectory in which the other utilities got to those levels of customer charges? Was it all at once or was it a gradual path?
No, I don't know how they got there to that point.
All right, let's move on to the changes in the demand charges for the classes that have demand charges. Is it my understanding, Mr. Crosco, that a lot of judgment was used in those numbers? They were not just cranked out of your class cost of service study?
Go
ahead, Mr. Crosco.
Judgment on demand charges. There might have been some, yes.
And with respect to the proposed changes in the existing time of use rate, I understand your testimony about generally using a shorter peak period and shifting it a little later in the day and applying it over fewer months, which I believe.
I don't remember applying it over. Yes, I do. Never mind.
And you know that the city generally does not take offense to that. But I would like to know why you did not use a uniform time of use period for the irrigation rate class number 5.
For the irrigation class, years ago, there was discussions that the company had with those kind of customers, those irrigation customers, and based on what we understand was that those customers requested that a 4-hour peak period for them with a higher on-peak charge, that would be more applicable for their purposes.
And how many years ago did you have those conversations?
I want to say 12 years ago.
So quite a while ago.
Yes, it's been a while.
And in conjunction with this particular rate case, you have not spoken to irrigation customers?
No, we did not. At least from the rates group. I don't know if our commercial services did talk to them. I don't know.
in making that decision for those that treat that class differently, did the company take into consideration the possibility that the irrigation customers would be incentivized to begin their irrigation at, what is it for them, 6 p.m. is it, or 5 p.m.?
I didn't understand what you said.
In making that decision to use a different time of use period for irrigation customers, did the company consider whether having that different end period of the peak period might incentivize those customers to basically crank up their irrigation systems at, is it 6 p.m., Mr. Crosco, I believe? I'm sorry.
Yes, 6 p.m. Right now, it's at 5 p.m., which is actually worse. So 6 p.m. is a better adjustment for that time period.
And wouldn't 7 p.m. like everybody else be even better in terms of being sure that you clear you don't create a new substantial load as your system may be peaking or close to peaking?
Well, it could be. There's no reason why it could not also work for them. If they still want to keep their 4-hour on-peak period, that means that they would start or they would quit or ramp down their irrigation at 3 p.m.
Mr. Crosco, do you work with the resource planning department and people like Mr. Omar Gallegos who are dealing with questions about how to integrate renewables into the company's generation supply?
No, not really. No, I know we work with them like during RPS filing time. That's about it.
So you didn't take into consideration the concept of the new evening peak that arises as solar generation goes offline when you were selecting your times?
When we selected our on-peak period, we looked at our actuals for our system loads over the last 5 years. And we determined that a 6-hour period from 1 to 7 would better address those system peaks, because not only are we picking up 98% of the hours that are within 90% of the peak, but we also capture those shoulder hours where either our system generators are ramping up or ramping down. So, and that's why we selected a 6-hour on-peak period, just to cover a broader peak period of our system.
I appreciate that. In using historical data for the last 5 years, did you also analyze a prospective situation in which the company will have more solar online and more risk of declining resources in the afternoon?
No, we did not consider any projection.
And now let's see. So we have the irrigation customers. Do you remember Mr. Provencio's testimony for the city raising the question of whether it's necessarily appropriate to have residential customers use that same peak period given their own class profile, as he recalls, as he understands the class load profile to be? I believe you offered some rebuttal to that, or might have been Mr. Aguirre. I cannot say for certain.
Yeah, and I'm recalling that Mr. Aguirre responded that our selection of on-peak period only considered the system peaks. It it didn't look at individual rate classes and how their load profiles fall. Because the whole intent is to influence at least a better system load factor. So we're looking at the entire system, not by rate class.
And that does lead us to something I didn't quite mean to get to here, but I will ask you about. So historically, would you agree that time of use, which are now being called time of day rates, have not been adopted wildly, broadly in New Mexico by your customers in New Mexico?
I know, like for Paso Electric, we haven't had very many interest in TOD rates. I don't know how P&M or SPS are doing.
I'm sorry, we haven't had interest in
adopting TOD rates.
POV.
POD, like time of day.
Thank you.
And that applies to residential, commercial, industrial, and irrigation customers, Mr. Carrasco?
I know we've had pretty good luck with irrigation, but not so much for residential.
And other commercial, not so much also? I know some of them are mandatory, but for the ones who have voluntary TOD in the commercials, how would you classify, how would you characterize the level of participation or interest?
I would classify it as low.
And do you get a higher level of interest and participation with your time of day or time of use offerings in Texas?
I'll say yes. It's a better, we have better participation in Texas.
And would that be specifically in the residential or the commercial side or across the board?
In the non-residential side.
So has this company studied ways to improve the attractiveness of time of day use rates that are voluntary?
Well, that's one of the proposals that we have is to offer a bill clause, a bill protection clause in several of our rates, including residential. So we hope that that can help. And we are also ramping up their energy, on-peak energy charge for residential. So hopefully that'll attract some more customers. So, so now it all comes down to doing a little bit of a better job at marketing a TOD rate.
That commentary about ramping up the on-peak energy charge, do you mean for non-time of use customers?
No, I meant time of day rate customers.
Okay. And is it your theory that by ramping up the time of use peak energy charge, you will get people to sign up for that because they think that they can, win this, play the game and win by not using energy on peak?
Yes, we're hoping that customers can see that there's a potential for savings, and at the same time, the company benefiting by a decrease in load during the system on peak hours.
And the way you actually designed the time of use rates, Mr. Carrasco, and I do not know whether I should say it's you or Mr. Aguirre, but I'm sure you were there, was to basically design the rates so that they're a time of day customer and an ordinary customer are revenue neutral over the year for an average customer in that class. Is that a reasonable way of summarizing your methodology?
That's a reasonable way of summarizing it, yes.
Now, by doing that revenue neutral approach, doesn't that mean that strike that question? Has the company researched whether other utilities have managed to increase participation in time of day use, day rates by approaching the original design of those rates in a manner other than this revenue neutral approach that the company took?
I'm not aware of it.
You're not aware? You didn't make that in any investigation?
No, that I'm not aware. I don't know if Julio checked on anything like that, but
okay.
I do not know.
And to your knowledge, has EPE studied the literature to determine whether there are other ways of designing a robust, desirable time of use rate structure?
Most time of use rates are used 2 rating periods. Some use 3. By that, I mean like there's an on-peak and an off-peak charge. There's other on or time of day rates, which may include shoulder peaks.
So if the company, I think that you understand, Mr. Carrasco, that the city wants time of use rates to be a win-win for customers and the company and reduce overall usage. So we are aiming towards the same goal. Do you understand that? So I'm just looking for ways to do that. And I guess I'm wondering whether you consider the proposal in this case to be a kind of a carrot incentive method or a stick, make people move to time of day rates and see what happens. Can you speak to that? I know you've got a lot of rate design experience.
In our proposal, we do have like you say, a carrot and stick, but we're also proposing mandatory rates, and that is mandatory rates can is I can't remember how you described it earlier, but anyways, that'll really incentivize load reductions in during off-peak periods.
So are you saying that you feel like you're using carrots and sticks, or mostly sticks?
We're using both.
And were you listening to the cross-examination of Mr. Schiestel about about the chart that showed in an old integrated resource plan report that showed the gradual over a long period of time sort of stair-step progression towards all time of use rates? Were you watching during that testimony?
Yes, I remember listening to it.
Do you feel that progression is moving at the correct pace, or too slowly, or too quickly?
I really don't have an opinion on that. I think that's a good goal for us, especially as we address reducing system peaks.
Is rate number 8, the water, sewer, and storm sewage pumping rate, the only rate in which EPE is proposing to require that all new accounts, proposing a change to require that all new accounts take service under time of day rates?
No.
which other rate schedules will now go from optional to mandatory?
For rate 4, which is general service, we're gonna request or require new customers with demands of 400 kW or greater to be on a.
I'm sorry, with demands for
400 kW, meaning kilowatts. So those customers will be required to sign up for a time of day rate.
And how many of the customers, well, presently, I guess those are new ones, right? Presently, how many of the rate number 4 customers have an over 400 kW demand?
That's too much detail you're asking me for.
Yeah, I don't know whether it's a large, whether that's the outer fringe or that's somewhere in the middle ground.
Well, general service runs from greater than 500 kW up to 800 kW. But how many are above 400? I don't know.
Okay, I'm sure it's in the record somewhere, right? There's so much in this record. Let me. I'd like to ask you about one of the other rates that specifically affects the city of Las Cruces, Mr. Carrasco, and that's the proposed electric vehicle charging rate number 42. And this is the exceptional rate in which you are proposing a 3, as you mentioned earlier, a 3-tiered energy charge, correct?
Correct.
And I know that you are familiar with the transportation electrification plan that the company filed in case number 20-00241 at the very end of December. Is that right, Mr. Carrasco?
Yes.
Can you explain why in the residential or the residential small commercial, the rate that you're proposing in this case, why you have a super off-peak rate that's very low and no demand charge for that period, but in the new rate filing for customers in a number of classes, commercial customers in several classes, you're now proposing a demand charge that's measured during that super low dead of night period. That doesn't seem to be consistent with your rationale for offering the low rate in this case.
We are including a demand charge in the new filing, and that is to make sure that it's an additional incentive for our customers to the electric vehicle owner customers to really charge in on the super off peak period from 12 or from midnight to 8 a.m. So it's just an additional effort just to incentivize when that charging will take place.
Why would a demand charge imposed during those hours incentivize customers to charge at those hours instead of the traditional demand charge that hopefully reflects more of this company's load profile?
I don't have the numbers in front of me, but if you'll look at them, it's a big drop from what the regular demand charge is.
Would those customers pay the higher of the demand charge that they would get but for their energy, their electric vehicle usage? I'm just trying to understand why you would, and I understand that the company does measure demand for most of these classes on just a monthly peak, and that has something to do with the metering, does it not?
Yes, it does. So other than challenging our metering department, yes, if a customer, one of our non-residential customers, if they decide that they're going to charge their vehicle outside that super off-peak, then they are going to pay the higher demand charge that's typically offered under their standard rate.
But then why would you also, wouldn't you incentivize them better to use the super off-peak rate and improve the company's low profile and all that sort of stuff by not charging them a demand charge in those early morning hours when we know that the company's load system does not peak and in fact is, ramped down very low often?
Well, you also got to think about the distribution system that we have out there. So that demand charge, that super off-peak demand charge for some of those rates, it is intended to recover some of those costs. But the biggest incentive is that it's a much lower demand charge than outside the super off-peak period.
Okay. I think that's all the questions I have, Mr. Krasko. Thank you very much.
You're welcome.
Mr. Lundin, you have 15 minutes.
Your Honor, I don't have any questions for this witness. Thank you very much.
Ms. Sewell, you have 30.
Thank you, Madam Hearing Examiner. Hello, Mr. Carrasco.
Hello, Ms. Sewell.
Would you please go to your supplemental testimony, Exhibit EPE 62 at page 10?
Page 10?
Yes, sir.
Yes, I'm there.
And beginning at line 10, you're discussing the special rate contract between EPE and Holloman Air Force Base, correct?
Yes.
And at line 13, you state, currently, this customer receives a monthly capacity credit equal of $12.82 per kilowatt, which represents the monetary value of the capacity provided by the Holloman Solar Facility. Is that your testimony?
Yes.
Does that capacity credit have anything to do with the energy output of the Holloman Solar Facility?
No, it's based on the load of the facility.
At line 19, you go on to say, the proposed retail rates for rate 10B are based on a test period that reflects a full 12 months of normal operation of the Holloman Solar Facility, correct?
Correct.
Did the operation of the Holloman Solar Facility reduce Holloman's energy usage during peak hours?
Did it reduce Holloman's consumption during on-peak hours? Is that your question?
That is my question.
I do not know.
So perhaps you would go to page 11, lines 5 and 6.
6. Okay, I'm there.
Does that refresh your memory?
Okay, so that for allocation purposes, yes, the usage went down, but whether Holloman actually reduced usage, I have no idea. And we'd have to look at both the generation from the facility and how much we deliver to them. And so I'm not really sure.
So what is the meaning of that sentence then? To the extent that this solar facility reduced this customer's usage.
That has to do with our allocation factors. So in the development of our allocation factors, we have factored in that a portion of Holloman's consumption is being provided by the solar voltaic facility that we have installed there. So that's what the intent of this sentences are.
Did the solar facility reduce the customer's usage or increase the customer's usage?
I do not know.
Will Holloman Air Force Base continue to receive a capacity credit under your proposed new rates?
No, it will not.
Did you say capacity credit?
Yes, sir, I did.
Thank you, ma'am.
Then how does the Holloman rates that are represented in 10B, how do they change with your proposed rates?
The revenue requirement from that customer, looking at just a from the system resources, is now reflective of just those system resources. And that's because they are being, their consumption is being supplemented by this new solar facility that's installed in their service area.
Would you please go to the direct testimony of Julio Aguirre, exhibit EPE 63?
Which is direct. Okay.
In several places in Mr. Aguirre's testimony, he makes statements implying that sending customers more accurate price signals is desirable. Would you agree that sending customers more accurate price signals is desirable?
I agree.
Would you agree that one benefit of more accurate price signals is to enable customers to make better economic decisions about their energy use?
I agree.
At page 7, beginning at line 19, Mr. Aguirre indicates that limiting demand charges will send better and more accurate price signals to customers. Would you agree with that?
Okay, hold on. Are you in direct testimony of Aguirre?
I am in exhibit 63, direct testimony of Julio Aguirre, page 7.
7.
Beginning at line 19.
Okay. Your question again, please?
Would you agree that limiting demand charges will send better and more accurate price signals to customers?
I agree.
At page 9, before I go there, I'm sorry. Why does limiting demand charges send more accurate price signals to customers?
Well, what's being stated there is that that we are going to recover up to 100% of demand-related costs through our demand charges. And what the intent here is that because of the revenue capping that was done, that none of that additional revenue requirement that was imposed on non-capped customers, that none of that is going to be included in the demand charge.
And how does that have to do with limiting demand charges, sending more accurate price signals?
That's has to do with that it's not going to be over 100% of demand-related costs. We're not going to go over 100%, although, I mean, we could, but we have chosen not to.
Go to page 9, please, beginning at line 7. Mr. Aguirre stated that El Paso Electric seeks to achieve a variety of goals through its proposed rate design, including encouraging energy conservation and potentially reduce customers' contributions to EPE system peak demand. Is that your testimony also?
Yes.
What is the objective of EPE's residential time of day option proposal?
It is also to incentivize better use of our system resources.
Do you have an objective number of participants that you're aiming for?
No, we haven't made any projections like that.
Do you have an objective of the change in energy consumption patterns to move usage off peak?
Repeat that question, please.
In your objective for the time of day option proposal, do you have an objective of an amount of change in energy consumption patterns to move usage off peak?
No, we don't.
Do you have an objective related to a reduction in peak demand?
No, we don't.
Does El Paso Electric currently offer a residential time of day option?
Residential, yes.
How many customers currently utilize the residential time of day option?
20?
What percentage is that?
I want to say less than 1% of our residential customers.
Previously, you told Ms. Stevens that you consider participation to be low. What is El Paso Electric's hypothesis for why there are so few customers participating in the residential time of day option?
I think that they haven't been marketed. But then again, I don't know how, I don't know if there has been any marketing and how customers have responded. Obviously, they haven't been interested in signing up for those, that rate. So,
do you also believe that participation in the residential time of day option would benefit from better rate structure?
yes.
Would you agree that a successful residential time of day rate option will result in more customers shifting usage from peak periods to off-peak periods?
I agree, yes.
Do you expect that El Paso Electric's proposed residential time of day rate option will result in a higher customer participation rate?
I know we are offering that bill protection clause of up to 250 customers, so I hope that we can get at least that many customers.
250 residential customers would represent what participation rate?
I don't have that percentage.
How much shifting of usage from peak periods to off-peak periods is El Paso Electric expecting if they get a 250-person participation rate?
We do not have that analysis.
Please go to page 10, beginning at line 14. Mr. Aguirre states, if a significant portion of fixed costs are recovered through volumetric energy charges, customers who reduce their energy usage avoid paying those fixed costs. Do you see that?
Yes.
Would you agree that customers reducing their energy usage is consistent with the goal of energy conservation?
Yes.
Would you agree that avoiding paying costs could be an effective motivation for a customer to reduce energy usage?
Yes.
Please go to page 12, line 10. Mr. Aguirre states, EPE's proposed changes to demand and energy charges are intended to produce more accurate price signals that communicate those price differentials to customers. Is EPE proposing to reduce demand charges?
We could look at the Schedule 3 and see what the impacts are to demand charges. I want to say that there are decreases to non-summer demand charges.
I'm sorry,
Non-summer?
Is non-summer when El Paso Electric experiences its peak demand?
No, it's not.
Please go to page 29, line 9.
There.
I have to get there. It's talking about the residential customers that will see a significant increase in their bills due to the increase in the monthly customer charge. Are these the customers that have lower electricity usage?
That's right, yes.
Would you agree that El Paso Electric's proposed increase to the customer charge effectively punishes customers for lower electricity usage?
Not sure the word punishes, but it would be reflected in their bill.
Would be reflected in a higher bill, did you say?
It would be reflective for the increase for low consumption residential customers. A large component of it would be due to the monthly customer charge.
Who would these customers be?
Other than low consumption customers, I do not know who they would be.
How likely is it that these are El Paso Electric's poorest customers who can least afford an increase in their bills?
I don't know what the likelihood is, what income levels they are. It could be customers with DG systems that have very low consumption.
What customers with what systems?
DG systems.
Don't we want to, I'm sorry,
Sorry.
don't we want to encourage DG customers?
I don't have any opinion on that. I just say that let's make sure we all pay our fair share.
On page 34 at line 16, Mr. Aguirre describes the residential time of day rate schedule as being designed to be revenue neutral to the standard residential service rate. Please explain what this means.
That means that when the energy charges for the residential rate class, when we design the time of day energy charges, the same amount of annual revenue would be recovered through the time of day rates as the amount that would be recovered under non-time of day rates.
Does revenue neutrality assume there is no change in consumption patterns?
Correct.
Did El Paso Electric do any sensitivity analysis with an assumption of change to consumption patterns?
No, we did not.
And when you say revenue neutral, do you mean revenue neutral for El Paso Electric?
Revenue neutral for the rate class.
Revenue neutral for the customers in the rate class?
The customer rate class in total.
Revenue neutral for El Paso Electric regarding the residential rate class?
Correct.
And is that revenue neutral for those that are currently participating in time of day option?
Okay, I'm trying to understand your question. So when we design our time of day rates, we apply what our load studies show for time of day customers for the residential class. And we assume that all customers in the residential class use the same proportions of on-peak and off-peak. So that's how that's determined. We don't set it at the specific time of day rates that we actually do have as far as customers.
And why is that approach of revenue neutrality an appropriate way to design residential time of day rates?
Well, because we have to assume that the rate class is going to we're going to recover the same revenue requirement whether all the customers are on a non-time of day rate or if all the customers are on a time of day rate.
At page 35, line 9, Mr. Aguirre indicates the residential time of day schedule includes an energy adder designed to recover 60% of EPE's incremental generation cost of $110.50 per kilowatt year. What is an energy adder?
Energy adder is a cost per kWh that that is reflective of a generation cost, which is on top of our normal off-peak energy charge. But it's just the incremental amount between the off-peak and the off-peak charge.
Why is 60% the right amount to recover in the energy adder?
We chose 60% because it's one of those judgment calls that a analyst needs to make so that a on-peak energy charge is reasonable, not too low, not too high.
Would you agree that other rate classes, you use different percentages than 60%?
Yes, I agree.
If 60% is the right amount to be recovered in the time of day energy adder for residential, why is it different for other time of day rate classes?
Other rate classes, they have different load profiles, so we need to factor in their load factors. And then we also need to somehow moderate whatever the on-peak adder will be. So we use that percentage just to come up with the reasonable amount of on-peak adder for all the other rates.
Please go to the rebuttal testimony of Julio Aguirre, exhibit EPE 65 at page 22, beginning at line 13.
Okay.
Mr. Aguirre references a recent survey report published by the Brattle Group on residential time of use rates. Do you believe the reference study supports your contention that EPE's proposed time of day price signals for residential customers provide a reasonable economic incentive for customers to consider participation and change their usage patterns?
I think it does, yes.
At this time, I'd like to introduce exhibit MLS 07. It is the National Landscape of Residential Time of Use Rates published by the Brattle Group in November of 2017. And Mr. Carrasco, is this the report referenced in Mr. Aguirre's rebuttal testimony?
Hold on.
Madam Hearing Examiner. I have a clarifying question. Is MLS 7 the same document that's already in the record as an exhibit to Mr. Carrasco's second supplemental? I mean, Mr. Aguirre's second supplemental as JCA 2S?
Yes, I think it is. But let me just confirm that. I believe it is.
Yes, it is.
May I continue?
Hold on just a minute.
Okay.
So Ms. Souls, this Brattle, your exhibit 7 is exhibit 2 to Mr. Aguirre's second supplemental testimony, which has already been admitted into evidence. So your exhibit 7 has already been admitted into evidence.
Which would be the easiest way for my questions then?
I would have him, if you have questions about that report, I would ask Mr. Carrasco to go to Exhibit 2 to Mr. Aguirre's second supplemental testimony. Since it's already been admitted, I'm not going to admit it a second time.
That's fine. Would you go there, Mr. Krasko, please?
Yes, I found it.
Please go to page number 6 in the presentation, and now I'm not sure how that works with the exhibit numbers.
The title of the slide.
Number of pricing periods. Looks like it's page 7. Number of pricing periods. Do you see the comment? I'm very sorry. This does not look like the one that I have. Please go to page 6, the one before. It's entitled Enrollment Distribution Across IOUs.
Yes, I see it.
You see the comment at the top. 60% of IOUs offering time of use rates have enrollment rates of less than 1%.
I see it, yes.
Does EPE believe that less than 1% participation rate would be successful?
No, I think it should be higher.
If 60% of the IOUs represented in this study have a participation rate below what EPE would consider successful, how can that be evidence that such price signals provide a reasonable economic incentive for customers to consider participation and change their usage patterns?
First of all, I don't know how their time of use rates are structured, so I don't know why they, meaning those 60%, I don't know why they haven't had success.
Is a possible conclusion from this presentation that historically time of day usage in the study has not been successful?
I agree. That seems to be what this slide indicates.
And Ms. Souls, your time is up.
Thank you, Madam Hearing Examiner. Thank you, Mr. Carrasco.
Thank you, Ms. Souls.
Let's go ahead and take a 10-minute break and come back at 4:05.
Thank you.
David, are you ready?
Yes, Your Honor.
Okay, Mr. Herman, you're up and you have 20 minutes.
Thank you, Madam Examiner. Good afternoon, Mr. Carrasco. My name is Keith Herman, and I represent Doña Ana County.
Good afternoon.
I wanted to follow up on some of the questions asked by Ms. Souls. Could you turn to the direct testimony of Julio Aguirre at page 30?
I'm there.
When you were discussing this, I was having a little trouble reading the bottom line in figure JCA2. Can you tell me what is the x-axis values?
So like looking at the first bar, the value that is shown there is 0 to 200, in other words, 0 to 200 kWh.
Okay, and that's, yes, kilowatt hours per month.
Correct. And then right under it, it's a percentage, and it's 7.41% of customers. In other words, 7.41% of residential customers use between 0 and 200 kWh per month.
Excuse me, Mr. Carrasco, I got mixed up. Which testimony are you looking at and which page or which exhibit?
I am on Aguirre's direct testimony,
Mm-hmm.
page 30. And we're
Okay,
looking at the graph there.
Thank you.
Can you tell me which column there has the highest percentage of customers?
It would be the third column. And it shows that it's 22.96%.
Okay. Now, when you were speaking with Ms. Souls, you mentioned that you did not know what demographic represented that first column with the 31.4% increase, correct?
Correct.
And you represented that it could be distributed generation or DG customers, correct?
I did say that, yes.
Is it your testimony then, or Mr. Aguirre's testimony that you've adopted that the need for increasing the customer charge is due to increased penetration of distributed generation customers?
No, it's not.
Are you aware of any analysis done by El Paso Electric to quantify the benefits to the utility system by the increase in distributed generation customers?
No, I'm not aware.
Thank you. Are you familiar with the final order in EPE's last rate case, 1500127?
Somewhat familiar.
If I could just represent to you that paragraph 138 of that order ordered EPE to further review rate 7 at its next rate case. Would you accept that?
Yes.
So with regard to rate 7, how would you characterize EPE's proposal? Is it an elimination, a modification, or a continuation?
In this rate case, it's a continuation.
And why are you proposing a continuation for rate 7?
There's a, we decided to not go forward with any modification to the rate class other than just including that rate class in our cost of service.
So regarding the costs to serve rate 7, how does it differ from serving rate 3 or rate 4?
It differs because rate 3 is more of a homogeneous load type of customer types. In other words, those customers that are 50 kW and less. And it also differs from general service because general service is also a homogeneous type of load customers, which are from greater than 50 kW and up to 800 kW. So rate 7 is not a specific end use type or a homogeneous load type. It is a special rate that exists only for governmental facilities.
So just to reiterate your testimony, is that rate 3 and rate 4 are more homogeneous than rate 7?
That's correct. They're based on loads.
Based on?
Loads.
Thank you, Mr. Carrasco. I appreciate your time. I have no additional questions.
Thank you. Have a good day.
You're on mute, Judge.
So Mr. Smith is up next and he had 10 minutes reserved. Again, he's not available today. I don't know if he was intending to waive his cross-examination of Mr. Carrasco. Is Mr. Wexler there? Has he had any communications with Mr. Smith about that?
Your Honor, I do recall, I believe when we discussed it at the beginning of whichever day that was of the hearing, him raising concerns with introducing other EP witnesses today because he had also had cross reserved for Mr. Carrasco, and it was my recollection that he had proposed possibly allowing him to present out of time, but that's just my recollection.
Okay, I think we will not complete cross-examination of Mr. Carrasco today. So I will not waive Mr. Smith's cross-examination of Mr. Carrasco. I'll allow him to do that tomorrow. So that means Mr. Simpson, you are next and you have 45 minutes.
Yes, ma'am. Thank you. And I just a quick point. I apologize for having my camera off. I was here and I just didn't realize I had not turned my camera on after break.
Thank you.
Mr. Carrasco, my name is Philip Simpson. I'm a pro se intervener in Las Cruces. And some of my questions have already been asked, but I do have a few remaining questions. Let's go to El Paso Exhibit 63, which is Mr. Aguirre's direct testimony.
Let's go to El Paso Exhibit 63.
Yes.
Which is
And
Mr. Aguirre's testimony.
Yes, that's Mr. Geary's direct testimony. And I'd like to go to page 35. And I'm on line 12 to 14. It says that the summer off-peak rate was designed 10% higher than the non-summer rate to increase the rate differentials and moderately increase the seasonality. And that's Mr. Geary's testimony that you're adopting, correct?
Correct.
So my question is, since the summer rates already include a much higher peak rate, shouldn't the summer off-peak rates be as low or lower than the non-summer rate to encourage electricity usage during the off-peak times in the summer?
In this case, I know that Mr. Aguirre wanted give an extra incentive in the summer, off-peak versus a non-summer off-peak, just for additional conservation, energy conservation.
I'm going to interrupt and pause you just for a minute, Mr. Simpson. Mr. Carrasco, has that sentence changed in light of EPE's revised rates based on its revised revenue increase?
No, it has not.
Okay, thank you. Go ahead, Mr. Simpson.
I want to make sure I understand. So I'm asking why the summer off-peak rate is higher than the non-summer rate all the time. I mean,
Yeah, and I responded that it was a additional incentive for conservation during the summer months.
Wouldn't a lower summer off-peak rate incentivize conservation relative to the on-peak rate?
Well, the on-peak rate is what it is, right? And in this case, we're saying that the summer off-peak rate is 10% higher than the non-summer off-peak rate. So the incentive is really on the on-peak rate.
Okay. Was there any analysis done to that numerically calculated that 10% rate, or was that sort of a, just a guesstimate to achieve that objective?
I don't believe there was analysis. It was just a judgment call.
Okay. Let's move on to El Paso Exhibit 62, which is your supplemental testimony. And I'd like to go to page 25, line 10.
Okay.
And earlier there was some discussion with Ms. Souls or Ms. Stevens about meeting with irrigation customers, and they preferred a 4-hour irrigation, 4-hour time of day rate for irrigation. Do you recall that?
Yes, I recall.
And here it says EPE has not met with any classes of customers to specifically receive feedback on TUD rates. So I guess that's any classes of customers other than the irrigation customers.
That's right.
Okay. I also recall that he testified that there are only about 20 residential time of day customers in this jurisdiction?
Yes.
How does that compare to the number of irrigation customers?
I know that we have many more irrigation customers than we do residential customers. I'm not sure the exact numbers though.
Okay. Well, doesn't the small number of residential customers make it relatively easy to ask their preferences regarding the length of the peak period?
We could do a survey of those customers. I will not disagree with that.
Okay. The next sentence talks about, mentions that El Paso Electric has found that such discussions are more informed and productive in the context of rate proceeding in which the parties involved have a more informed understanding of rates and rate design principles. And I acknowledge that there are parties with some good understanding here. But my question is, would gathering the opinions of the users provide additional information on customer preferences to augment rather than replace the expert recommendations?
Maybe, because we just don't know what these customers would think would be a better rate design. I know that our rate design is focused on, especially time of day rates are focused on addressing those system peaks. And even though maybe those individual customers could provide good feedback, we have to see and we have to design our time of day rates with a larger view, not just specifically for those 20 customers.
Okay. So staying in this same exhibit 62, but I'd like to take you all the way to the back. Well, not all the way to the back, but to your exhibit MC2S, page 1 of 2. In the PDF, I believe it's line 50. That's helpful for some.
Okay, yes.
And am I correct in viewing this as a comparison of standard residential rates versus TOD rates for over a whole year?
Yes. We have summer and non-summer bills.
Okay. So I'm looking down at line 32, and that's sort of the average user, correct?
Yes.
So it shows the bill difference is $1.50 or 2.67%, correct? And that's an increase in the bill for a time of day user.
Yes, a difference of $1.50.
Okay. So let's go back up to page 17.
Okay.
Line 8 to 11, which is referring back to that exhibit. Actually, I think it's referring to the following page. And it shows that if the average residential TOD customer that consumes 659 kilowatts shifts 16% or greater, parentheses, i.e. 27 kilowatts or more, kilowatt hours or more, from on-peak to off-peak consumption, it will result in a bill that is less than or equal to a bill under the standard rate. So there was some discussion earlier that these rates were essentially revenue neutral, but what this is saying that to get to revenue, I'm sorry. Did you have a question, Mr. Lee?
No, sir.
Oh, okay. So in fact, these rates are not quite revenue neutral, correct? Because a residential user would have to shift 16% or more of his usage off peak to achieve revenue neutrality. Is that right?
Hold on, let me read the question. I'm reading the question on page 15. So the question is that what would the change have to be for his consumption patterns to be lower than same bill for non-TOD customer? So yes. So looking at page 2 of MC2S, line
Okay, so you're
30.
going back down to the exhibit.
Yes, I'm back in the exhibit. I'm sorry.
Okay. I'll go down there.
Line 30. We're back at that 659 kWh. So you'll see that the TOD customer, their seasonally weighted monthly bills, just a penny difference.
And that's after reducing by 16%, correct?
Percent, right. But don't, as I explained earlier, how the revenue neutrality works, we're looking at the entire rate class, and not really individual customers. That's how that revenue neutrality works. And we'll get close when you look at an individual customer. I mean, you're looking at $1.50 difference. And then I'm back at MC2S, looking at 32. We're looking at the maybe like the 10th column OPR in the summer.
I'm sorry, say that again. You're looking at what now?
Under the column OPR in summer, that's like the third to the last column. It's 25.96%. So that's like that number is what our load studies show for our sample number of meters. And although a sample is supposed to be representative of the whole population, so that's why you see a difference here. I mean, it's very difficult to be able to say, yeah, this customer is going to be paying exactly the same amount as this other non-TOD customer. But we work with the data that we have, and that's what it shows, and that's what the average customer, TOD customers, OPR is 25.96%. So yeah, going back to revenue neutrality, it's based on the the revenue rate class, not necessarily each individual customer.
Okay, well, I'm in the text and in this page 2 of 2 in the exhibit, it sort of highlights this average customer with 659 kilowatt hours of average annual or average monthly usage. And the fact that this average customer would have to reduce their consumption 16% or reduce their on-peak consumption by 16% just to achieve revenue neutrality. Why not structure TOD rates to be completely revenue neutral for an average customer? At the very least.
Like I mentioned, an average customer, in this case, the customer that's using their on-peak ratio in the summer is 25.96%. That's a number from our sample meters. I don't know how many meters we have out there, but it's supposed to be representative of our total population. So, so our rate design is based on this 25.96% that our load studies are showing. That's the best data we got. It'd be nice to have better information, of course, but that's all we have for now.
Okay. Well, well, let's move on. If TOD rates were revenue neutral, wouldn't any shifting of the load away from the peak period be a potential cost saver for El Paso Electric by decreasing peak demand and decreasing the need for generating resources?
There could be some savings there. I'm not sure what our variable costs are during on-peak hours. And then, so there could be some savings there.
Okay. Can you, I know this is not a simple calculation, but can you give some idea of what the impact on rates would be if you changed the time of day peak period from 6 hours to 4 hours?
That is not a calculation I can do here. No, there's too many factors involved.
Okay. Well, that is all the questions I have. Thank you very much for your time, Madam Hearing Examiner. I turn it back to you.
Ms. Drake had 10 minutes reserved, but she's not here, so she waives. Mr. Marks, you have 40 minutes. David, if we do the 40 minutes, that would bring us to about 5:15. Is that okay with you?
Yes, ma'am.
Miss Glick, if it's possible, I'd like to quit at 5. I had scheduled something else for 5 p.m.
Mm-hmm.
And
I mean, that's fine. Do you want to start today, or do you just adjourn early?
Ms. Glick, I just assume start now. I mean, if EPE doesn't object and think I'm getting some unfair advantage by breaking into 2 days, I just assumed run from now to 5. You're already doing a great job getting us ahead of schedule.
Okay, that's fine with me. Why don't you go ahead then?
Thank you. Good afternoon, Mr. Carrasco.
Good afternoon.
I think you probably already know this, but I'm representing Yellowbird Services in this matter. If we could look at your supplemental testimony and pages 25 and 26.
Mr. Marsh, you'll need to talk into the microphone. I heard you, but it's fading.
Okay. You discussed the principle of gradualism as a reason not to go all the way to a 4-hour on-peak period. Could you explain more what that means?
25 and 26.
At the bottom of page 25, line 19, EPE believes the current 8-hour period cutting from 8 to 4 hours is not reasonable, and continues on to the next page.
Yes, okay, I'm there.
Would you agree with me? You're talking about the principle of gradualism?
Yes.
Okay.
I agree.
And can you explain what you mean by that in this context?
In other words, so right now, residential time of day rates are have an on-peak period of 8 hours. And so what we are proposing is to reduce that 8-hour peak period to 6 hours. And that is because our analysis shows that 6 hours captures 98% of those system load hours that are within 90% of our system peak.
And Mr. Carrasco, could I get you to take a look at what we have marked as Yellowbird Services YBS Exhibit 8 for the hearing? And I'll be referring to the one that says excerpt, which is just EPE's response to YBS Discovery Quest 2-4. Do you see that?
Yes, I'm there.
Okay. And that's a response you sponsored, correct?
Yes.
And that shows the number of customers who elected to opt into TOD rates.
Correct.
Okay. Madam Hearing Examiner, I would move admission of Exhibit YBS 8.
Is there any objection?
No objection.
Exhibit YBS 8 is admitted, and this is the version labeled excerpt.
And Ms. Sewells, and I think Mr. Simpson covered this already, but this shows that there are very few customers in those time of use rates, both residential and in the other classes. There's 20 right now in residential, correct?
You're asking me? Yes, that's what the table shows.
Okay. Do you know if any of those 20 residential customers in TOD are EPE employees?
I do not know.
Okay. Is your concern about gradualism, about making a big change, is that a concern about making an abrupt change for the 20 residential and 13 commercial customers who are currently on time of use rates?
Hearing examiner, I just have an objection to his use of the word current. If he's referring to the exhibit, I think the numbers go through 2019.
Well, I think Mr. Carrasco said in his testimony that, his oral testimony, that there are still currently 20 residential time of day customers. But let me clarify, is that correct, Mr. Carrasco?
Yeah, I want to say that there are 20 customers currently.
Okay, so I'm overruling the objection.
I don't want to say, I will say, but there's 20.
I just wanted to be clear that we weren't talking about the exhibit.
Okay.
Would you like me to repeat the question?
Yes, please.
Is your concern about gradualism, which we saw in your supplemental testimony at the bottom of page 25, top of page 26, is that concern about making too abrupt a change for the 20 residential customers and the approximately 13 commercial customers who may be on time of day rates now?
No, like I mentioned previously, our concern is that we have a on-peak period that better addresses our system loads in the summer. And that's why we have chosen a 6-hour on-peak period that can really help us with that.
So on the page 26, line 4, at the end of that line, you said more gradual. Does making the change more gradually, not going all the way from 8 hours or from 12 hours to 8 and then to 4, is that really a concern of EPE's, or did you pick 6 hours for reasons unrelated to the history of the rate?
We picked 6 hours because it better addresses our summer on-peak periods. So we capture more of our hours when loads are nearing our system peaks. In fact, we pick up 98% of them in that 6-hour period.
Okay. And would you agree there are approximately 88,000 New Mexico residential customers for EPE?
Yeah, we have about 80-some thousand customers.
And
excuse me, Mr. Marks, is that New Mexico or New Mexico and Texas?
That's New Mexico is
Okay.
the question.
Go ahead,
And-
sorry.
Sorry. And the challenge for EPE is to attract a sufficient number of those customers who are not currently on TOD to join this, correct?
Correct.
Okay. And for all intents and purposes, if it's successful, it'll be a wholly new program, not a continuation of the program with just a handful of customers we have today, correct?
Correct, yes.
Okay. If you could look at Mr. Aguirre's second supplemental and the Brattle study, which is at JCA 2S.
Yes.
Okay. And look at page 7 of 24.
Yes, I'm there.
Okay. Do you see that third bullet point there, which says that APS has over half its customers enrolled in TOU?
Yes.
So you would agree that it's at least theoretically possible to have a successful TOU program?
That's right. Yes.
And the fact that many utilities, including EPE, have poor participation rates doesn't mean the concept is unworkable.
I agree.
Thank you. And do you see the fourth bullet point?
Yes.
And it states reasons that Brattle found for low enrollment?
That's right.
Okay. And is one of those reasons a long peak period?
Correct.
Okay. And another, lack of promotion?
There's no marketing.
Okay. And does this page in the report or any part of Brattle's report say that a reason for low enrollment is risk aversion and a lack of bill protection?
It does not list that.
Okay. And then
Bill
if we look at-
protection. Did you say bill protection?
Yes, I did.
Thank you. Go ahead.
Yes. And if we could look at page 19 of in that same exhibit.
Yes, I'm there.
Well, let's let's just skip that here. Can we go? Let's go to the exhibit JCA 1S, which is ahead of that in this same document.
Okay.
And if you could go to page 17 of 43.
Yes.
Okay. And that is a summary of APS's time of day rates, correct?
Yes.
Would you agree that APS does not use a 6-hour on peak, they use a 5-hour?
Yes. That's what it shows.
Okay. Does APS include bill protection in its time of day rate design?
I don't know.
Do you agree that in the Brattle study, and if you need to look at it, it would be page 12. They found about 1/3 of all the utilities offered 2 distinct time of use options.
Page 12, you said?
Yes.
Yes, I see. That's the first bullet.
Okay. Is it possible that EPE might attract more customers to time of day rates if it offered both the 4-hour time of day rate design that Mr. Bacchus recommends and the 6-hour time of day design that EPE prefers?
possible. Yeah. Okay.
Mr. Marks, I'd like to go ahead and stop for the day with your cross-examination because there are a couple things I want to discuss before we end, and you probably want to participate in these discussions. You have 25 minutes remaining tomorrow. So the first thing is, Mr. Carrasco, I want to give you notice of 2 more questions that I'm going to have for you in addition to the ones I've already given you notice of.
Okay.
And the first is, in response to Ms. Stevens' cross-examination, you said that EPE has seen higher participation from its Texas customers than its New Mexico customers in non-residential time of day rates. And I just want to know whether you know why. My second question is, and this is a question I've been struggling with, or an issue I've been struggling with. At page 23, lines 4 through 6 of Mr. Aguirre's rebuttal testimony, he says EPE's proposed changes to its residential time of day rate offering provide a reasonable economic incentive for customers to consider participation and change their usage patterns. So we have, the Public Utility Act has a statute 62-8-6, which I'm sure your attorneys can show you, entitled discrimination. And so your attorneys can show you this, so you don't need to write it down word for word. I'll just read the first sentence of that statute. No public utility shall, as to rates or services, make or grant, excuse me, make or grant any unreasonable preference or advantage to any corporation or person within any classification, or subject any corporation or person within any classification to any unreasonable prejudice or disadvantage. So I don't know if I'm going to be articulating my question real well because I'm struggling with it, but maybe it's a couple questions. Is a purpose of the time of day rates to give an economic advantage to customers who participate in time of day rates? That's one question. If it is, does that violate section 62-8-6? I mean, I'm just really struggling with, I know a purpose of time of day rates is to shift use off peak, but I'm also wondering, you know, is a purpose also to give an economic advantage to persons who participate in those rates? And again, does that violate section 62-8-6? Okay. Okay, so the second thing I want to discuss is I think we need to revise the witness schedule for tomorrow and Friday because we're quite a bit ahead. So if you could all get out the revised witness schedule that I emailed this week. I don't know if Ms. Olson, you need to get Mr. Wexler involved with this or not.
Mr. Wexler is here.
Okay.
So, yeah.
Okay, so for tomorrow, the witnesses I had listed were Mr. Hernandez, Mr. Novella, Mr. Carrasco, and Mark Garrett on standby. So we've completed Mr. Hernandez. I figure we've got maybe an hour and a half left tomorrow for Mr. Carrasco, probably not even that much. So if you add up 2.22 hours for Mr. Novella, 1.5 remaining for Mr. Carrasco, and 1.33 for Mark Garrett, you have about 5 hours. David Garrett is not available tomorrow, so we cannot move him to tomorrow. But what I'm proposing, and I guess I
Madam
need
Examiner, if I may
yeah.
correct you, I've been talking with Mr. Garrett, and I believe he is actually going to be available tomorrow.
Okay.
So if I may just propose, we could have Mr. Garrett or Mr. Mark Garrett, Mr. David Garrett, and then Mr. Harriger on standby. That should fill up Thursday.
Well, I think we should actually, I think probably David Garrett will go tomorrow. Because as I said, if you add up Mr. Novella, what's remaining of Mr. Carrasco and Mark Garrett, you have about 5 hours. So then if we add on David Garrett, it's a little over 6. So I'm pretty sure he'll go tomorrow. So I think we need another person after David Garrett. I was wondering if Mr. Harriger is available tomorrow.
Yes, he could be on standby tomorrow.
Okay. And I think we need another standby for tomorrow. So could Ms. LaRock go tomorrow?
Madam Hearing Examiner, yes, I did this little arithmetic myself during our previous break and have already summoned up our troops, and we're lining up so that we can be ready whenever you need us.
Okay, so for tomorrow, let's see. Ms. Olson, I'm assuming will complete Mr. Carrasco before we go on to Mr. Novella. Is that right?
That's okay with us.
Okay, so we'll complete Mr. Carrasco. Then we'll go to Mr. Novella, then to Mark Garrett, then to David Garrett, and we'll have on standby Mr. Harriger and Ms. LaRock. So then Friday, we might be starting, depending on how quickly we go tomorrow, we might have Mr. Harriger on Friday, Ms. LaRock. So then is Mr. Reyes available on Friday?
Yes.
He's already standby for Friday.
Who said that?
What's up?
You said yes.
Anastasia
Oh.
Stevens, his attorney. Thank you. I'm sorry, Mr. Lee.
What about Mr. Provencio?
It's Anastasia again. Yes, he will be.
Ms. Souls, would you be available Friday?
Yes, ma'am, I can.
Okay. So let me add up the hours on that real quick. See where we are. And I'm gonna assume we'll start with Mr. Harriger on Friday, although we may get to him tomorrow. But see.
Yes, he'll be standby Thursday, definitely Friday.
Oh, I screwed up. Just a second. So through Ms. Souls, then that would bring us to about 6 hours on Friday. So Mr. Lundin, I'm wondering if Ms. Crane and Dr. Gigax could be available for standby on Friday. And he's not answering. Let me see if I can pull him up on my cell phone. Okay, he's not answering, so I'll put them on I'll revise this tonight and send it out. I'll put Ms. Crane and Dr. Gigax on standby for Friday, and we can readdress that tomorrow when Mr. Lundin is here. So does that sound okay? Okay. Anything else before we go off the record? Okay, thank you very much.
Anastasia, do you want to join that